Lordship, item number 1.
May I please, Your Lord? And here your Lordship was pleased to, my Lord, issue notice to the opposite party number 5, new added opposite party, my Lord, by virtue of the direction of your Lordships. And AD has not.
Pardon, my Lord. May I pardon, my Lord? My Lord, may I, sorry to mention, my Lord, one item 65. There is a PIL matter. Let's me remember the Ames treatment matter. So it is on the process of issue. So can we given another 2 weeks time, my Lord? Lordship directed me to file an affidavit. So laws and health secretary requested to give all this.
No, but who's for the petitioner?
I have already intimated Mr. Dhal is appearing for senior advocate Mr. Dhal, DP Dhal. I already have sent a message to him. I also am requesting.
Or is there an interim order? No. There's no interim order.
Directed to start the treatment. Already 9 patients has been rushed to the AIMS and we have extended our.
Actually, there was one more petition, Mr. Padi.
Yes.
One fresh petition had been filed. We said on the same basis you should extend for this man.
Yes,
it's today. So there will be 2 matters then. Which is that item number?
65.
65.
All right. At the request of Mr. Padi, who needs some more time for instructions. List on 9th November.
Oblige, man. Oblige.
Item 1.
And your Lordship was pleased to direct to add the opposite partner 5, newly opposite partner 5, and issued notice to the opposite partner 5. My Lord, AD has not come. They were the.
What is the service? AD not back from open number 5. Public health engineering.
It is a small matter, my Lord. If Lordship will be pleased enough to dispose of. Here, my Lord, sewerage line is not available in the houses of the sector.
No, but who will appear for PHEO? You will know.
AD, my Lord,
that public health engineering organization.
So they have their set of council members.
Do you know which is the name of the council?
They changed recently. I'll collect that information and I'll suffer punishment.
The AD card is not back from opposite party number 5. That is the Public Health Engineering Organization. Bracket PHEO. Notice now be issued Dasti. You serve it in person. Additionally, notice also be served upon Mr. So-and-so advocate who stated to be appearing for PHEO generally. 16th November.
What will short date may be given? 28th, my Lord.
68th November. 16th. Let them take instruction also.
The fact remains that, my Lord, the sewerage line is not available since 2012.
I know.
Money has been sanctioned, my Lord, by CDA.
Let them come and tell us, sir. Let them come and tell us.
Item number 2.
Should I implement this? Lord, you could kindly see last order dated 3rd of August 2022. The opposite parties 3, 4, 5, 6, they did not appear, but then your Lordship, in the interest of justice, adjourned the matter to today.
Correct.
Lord, today, Lord, I request your Lordship, probably my landed senior is appearing for Jharsuguda Regional Improvement.
I am appearing for the petitioner.
Petitioner. Item 2.
Item 3.
No, 2 is being called out, sir.
2, sir.
Item 2 is being called out.
Item 2. Lord, today, I think the same situation prevails, but then I request your Lordship to dispose of the matter because notices are
right.
My simple prayer for Lordship would be to preserve the public utility space for the purpose it was approved by the Jharsuguda Regional Improvement Trust.
Right.
It was approved for the purpose of a clubhouse. Now, my client's allegation is that instead of a clubhouse, they are trying to raise a shopping complex over that earmarked area.
So we'll confirm the interim order then.
And direct the Regional Improvement Trust to ensure that that space for the purpose it was approved should be maintained. That's all.
All right. You see, the prayer in the present petition was that the plot in question, which is earmarked for a clubhouse, should not be utilized for any other purpose, particularly for any commercial purpose by the Jharsuguda Regional Improvement Trust, bracket JRIT, as well as the Jharsuguda municipality.
Not by the private opposite parties, builder.
And the private opposite parties 5 and 6.
Right.
Paragraph. As noted in the previous date, that is 3rd August 2022, none has been appearing for opposite parties 5 and 6, and for that matter, even for 3 and 4, despite service of notice. Full stop. The same position continues today as well. Full stop. There has been an interim order asking parties to
Maintain status quo, 22nd of March 2013.
requiring parties to maintain status quo since 22nd March 2013, and that has continued till date. Paragraph. In the circumstances, the interim order is made absolute, and a direction is issued to the opposite parties, 3 to 6, to not allow the plot in question to be used for any purpose other than the earmark purpose.
Yes.
Full stop. The petition is disposed of.
Great.
Number 3.
Well, in this case, I have challenged the order dated 18/5/2005 of the Secretary, Urban Development Department, in dismissing the appeal, upholding the order of the opposite party number 3. But in this connection, this honorable court has granted twice time to the state government to file counter. They have not yet filed counter. However, my lord may see the bill.
What if you not do 18/5/2011, 2013?
Yes,
Or is it 2013?
18/5/2013. Wherein the order of the opposite party number 3 was confirmed by a non-speaking order. But short facts leading to the present case is that the building plan was passed by letter number 2421 dated 17/4/1974. Prior to passing of this act, the Odisha Development Authority Act. And thereafter, admit the boundary wall, building and other construction over the plot in question A/49 were duly completed during the period from 74 to 80. That is prior to enactment and coming into force of the Odisha Development Authorities Act. G+2.
How come nobody is appearing for BDA?
I am appearing for BDA. Milords, I am appearing for BDA, Milords.
Then what are your instructions? Nobody seems to be interested. BDA is running a counter.
They have.
There is a stay order since 2013. There's no complete indifference.
I will satisfy the court on the facts of the case from the documents which has been annexed. Your Lordship, let him complete. I will satisfy from the documents which has annexed to the writ application. This case is not maintainable. I am extremely sorry that counter has not been filed. I take apology for that, but let him complete the.
All right.
My lord, in this case, my submission would be, according to the order judgment of the Honorable Supreme Court of India, if counter has not been filed, then
No. There's no judgment for that. So you have to satisfy the merits. Don't go that route. We are not going to be saying that because no counter is filed, writ petition is allowed. You forget that.
Well, I am filing the.
You please argue on merits now.
Two judgments I will file. Admit
You have no other argument.
Wall.
You have no other argument except saying that because counter is not filed, writ petition should be allowed.
That is one of the.
You go to your next argument on merits now.
Well, admittedly, the boundary wall, building and other construction over plot number A/49 were completed during the period from 74 to 80. That is prior to the enactment of Odisha Urban Development Authorities Act. G+2-story building and AC shed were also constructed in accordance with the provisions of Chapter 14 of the Odisha Municipal Rules 1953 and Chapter 17 of the Act. Rule 554F of the Odisha Municipal Rule 1953, one garage and chowkidar post can be constructed on the setback area. Well, the construction over the plot was duly constructed and completed in accordance with the rules and duly approved by the competent authority of the Bhubaneswar NSE, and the construction of the building was completed under the Odisha Municipal Act 1950, have been saved under section 128 of the Odisha Development Authorities Act, my lord. I am reading that.
Sir, are you aware what the case against you is?
My lord, all the laws, the rules, Odisha Development Authorities Act, the section and Odisha Municipal Rule is applicable in this case, and they support my contention.
Sir, I'm again repeating the question. Do you know what the case against you is? Are you aware of that?
Well, according to me, no point was against me.
Sir, please come to page, the next page, page 39. You're reading page 38, now read page 39. I don't know how you prepared for this case. When you prepared for this case, you did not know what the case against you is.
No, my lord, I got the list of late at about 10:30.
Only you read what is in your favor at 10:30, not what is against you.
My lord, according to me,
sir, without reading, you are able to tell us that there's nothing, no case against you.
Yes, my lord.
I see. Okay, we'll now listen to him. We are able to read what the case against you is. You are not able to read. It's unfortunate. We are clearly able to read what the case against you is. You are not able to read.
My lord, my submission is no point is available for them to raise
Sir,
against
if this
me.
is how you're going to argue, it is really unfortunate, sir.
I am arguing.
This is so unfortunate that the lawyer who gets up to argue in a court does not know what the case against him is, does not have a reply to what is against him.
My lord, let me put up first my submission. My lord, according to the plan was passed and the house was completed prior to this enactment. Therefore, my submission is this law has no application in the present case and it cannot be pressed into service in my case.
You have concluded your arguments.
No, my lord, I will answer to if they raise something.
According to you, they have not raised anything.
Yes.
I see. It's remarkable, sir. What we are able to read, you are not able to read. It's remarkable.
My lord, I have.
Is there an order against you? You have come in writ petition to this court.
Yes.
Have you challenged an order?
Yes, my lord.
Is that order against you?
That order I have challenged here.
So that order is against you?
Yes, my lord.
It is against you on certain grounds.
The grounds are untenable because of this.
All right. This is your only argument.
Not only argument.
It's only. Kindly take your seat, sir. This is, I don't know why we are breaking your heads. You do not, why should we break our heads? Yes, Mr. Mukherjee. You tell us your case now.
Kindly turn to the page 21. That is the building approval plan.
Yes.
The building approval plan is valid for 1 year. That is not important. Point number 5.
Yes.
No compound wall should be constructed within 5 feet from the boundary and conservancy lane.
Right.
Your lordship now comes to the finding of that is that the pages are distorted, but I will try to put that is at page 28 of my brief. That is the order passed in UOP 684 of 2012.
Yes.
May I place the order?
Yes, please. Yes, please.
CR is placed today. OP is absent. On the last date, so and so on behalf of opposite party was present, informed through advocate to submit approved building plan, but he fails to submit the same. Although a plan has been submitted by him on 8/11/2012, this does not bear the signature of any officials of the erstwhile NSE Bhubaneswar. He has submitted a copy of letter dated so and so. The content of the letter is as follows. With reference to a letter dated so and so, enclosing plans from a scrutiny, it is observed that the general plan and the elevational treatment are satisfactory, and hence plan has been approved. This is not has not been signed by the competent authority. Out of 5 copies of the plan sent, 1 copy is retained for the purposes of record. Further, he has submitted a copy of the letter dated letter of the Special Planning Authority, in which the permission was granted for construction of residential building plan, not the boundary wall, over plot number so and so. In the said letter, the opposite party was asked the building plan will be approved by NSE. The NSE letter has also approved the building plan only over plot number so and so. Now the next page, that is page 27 of my brief, submitted by OP, in the said letter dated so and so, the following stipulation was given.
Yeah, you already read this, sir. You already read this.
No compound wall. Now,
Correct. That you have already read.
yes, but last portion, taken into account the above stipulation, the opposite party should have left 5 feet back and should have kept vacant space for planting trees. As reported, the opposite party has taken up construction without leaving proper setback on the north side and on the side each side. He is under obligation to leave minimum 5 feet setback on each side as indicated. As reported, the opposite party has taken up construction of the boundary wall. This should be viewed seriously. The construction that he has been taken up within 5 setback area is held unauthorized and illegal, and hence should be demolished. Now, Your Lordship may kindly come the appeal order, which is at page 38 of my brief.
That's the same thing, sir. All this is repeated in that order.
Yes.
That's all.
So the permission which was granted, it was the stipulation was clearly mentioned that he cannot make a boundary wall within 5 feet. And the finding of the court below that he has made boundary wall within 5 feet, so it was unauthorized.
No, he's also got extra possession.
And he has got extra position. Now I will take Your Lordship to a letter of the state government, that is, my lords, at page annexure 3, page 19 of my brief. May I please?
Yes, carry on, please.
I am directed, this is to the petitioner from the GA department. I am directed to say that field inquiry report of RI of the department reveals that government land measuring so and so in the western side of the above plot has been encroached within the boundary wall. You are therefore requested to please intimate this department early if you are willing to take permissive possession of the above land as per prevailing rules. Then at the next page, that is annexure 4, page 20 of my letter of the brief, this is a letter written by the petitioner to the GA department that I am willing to take possession of the above. Now, he says that permission has been granted by the GA department, but no such permission is available in this brief. So he has constructed a boundary wall without a permission, has encroached upon the government land without any approval from the state government.
All right.
Madam, kindly see page 26.
Yes.
Para 4.
Yes.
It is pertinent to mention here that the building plan over my plot number A by 49 was approved by the erstwhile NSE Bhubaneswar by letter number 2421 NSE 17474, which was renewed from time to time till 25/7/81. The last renewal being letter number being letter number 9901 dated 25/7/80, the boundary wall, the building plan and all construction over plot number A by 49 were completed during the period from 1975 to 80, that is prior to enactment of the ODA Act 1982. The construction of G plus 2-story building and SEZ were duly constructed in accordance with the provisions of Chapter 17 of the Municipal Act 1950, then in force. All such actions have been duly saved and protected under Section 28 of the ODA Act 1982. And my submission is, ODA Act came into force on 1st day of September 1983. All construction, and it is prospective. All construction and the allegations made therein are false because it was done within the one prior to the coming into force of the ODA Act. Well, therefore, the section 128 of this Act saved the prior construction which was done earlier to the Act. And my lord, in the absence of any counter affidavit filed denying this position, I will cite the decision of this honorable court in 2017 1 order 222, holding therein principle of non-traverse. In the present case, since the opposite parties have not filed the counter affidavit to controvert the contention raised in the writ application, the facts which have been pleaded by the petitioner are deemed to be admitted. Any argument advanced by the learned counsel appearing for the opposite parties cannot sustain in the absence of any pleadings thereof. But another judgment of the Honorable Supreme Court of India, Judgment today 1993, Volume 5, Supreme Court 223. Every allegation of facts in the plaint, if not denied specifically or by necessary admitted in the pleading of the defendant, shall be taken to be admitted except as against a person under disability. Under Section 128 of the Odisha Development Authorities Act, Section 128 saves the provisions. As from the date of the constitution of the authority, the Odisha Town Planning and Improvement Trust Act 1956, Odisha Act 10 of 1957, and Section 247 to 251 of Chapter 17 of the Odisha Development Authorities Act, 217 of the Chapter 17 of the Odisha Municipal Act 1950 shall cease to have effect within the area under the jurisdiction of the authority. The Improvement Trust and the Special Planning Authorities as to existing planning authorities constituted under the provisions of the said Act in respect of whole or part of the area under the jurisdiction of the authority shall stand dissolved. Section 128. And my contention is whatever was done, that was prior to enactment of this Act, and it was permitted to be done by the appropriate authority, by opposite partner.
Did they permit you to do or they said you should not do?
Sir?
Did they permit you to do or they said you should not do something?
No, permitted to do.
I see. All right. All right. Fine, sir. Fine. Anything else, sir? That's right. So if you're finished, we can dictate the order with your kind permission. All right. All right. The challenge in the present writ petition is to, and kindly do not interrupt, sir. That's the only request. All right.
No, Your Honor has not started it.
So you will wait to interrupt only after I start. All right. All right. The challenge in the present petition is to an order dated 20th November 2012, passed by the Officer on Special Duty under the Orissa Development Authorities Act 1982 bracket ODA Act, Bhubaneswar Development Authority bracket BDA. In UAP number 684 of 2012, directing the petitioner to remove the unauthorized construction. Full stop. The challenge also is to another letter dated 22nd November 2012, passed under section 91 bracket 1 of the ODA Act, and an order dated 18th May 2013, passed by the Principal Secretary, Housing and Urban Development Department, bracket HUD Department, bracket Government of Orissa. Again requiring the petitioner to remove the unauthorized construction. Full stop. It must be mentioned here that the appeal filed by the petitioner, being appeal case number 140 of 2012, was dismissed by the Commissioner cum Secretary, HUD, by the impugned order dated, by the further impugned order dated 18th May 13, which has also been challenged in the presented petition. Paragraph: this court has heard the submissions of learned counsel for the petitioner as well as learned counsel appearing for the BDA. It must be mentioned at the outset that while directing notice to issue in the present petition on 17/12/2013, this court had stayed the operation of the impugned order dated 18 May 2013 of opposite party number 1. Paragraph. The background facts are that a piece of homestead land, residential site, at measuring 110 feet into 69 feet 6 inches in plot number A by 49 in unit Roman capital 3, as per drawing number 503 near Gurudwar at Bhubaneswar, bracket hereafter the plot in question, bracket, was granted in favor of the petitioner on lease by the Government of Orissa. Full stop. It is stated that possession of the said land was delivered to the petitioner on 4 July 1972. Paragraph. It is seen from the documents enclosed with the petition that by a letter dated 17th April 1974, the plan for construction of a residential building on the plot in question was approved by the notified area council, bracket NAC, bracket Bhubaneswar, with certain stipulations, one of which was that, open quotation, no compound wall should be constructed within feet from the boundary and conservancy lane, unquote. Further, it was added that adequate space should be kept vacant in the compound for planting of trees. Full stop. On 8 March 2000, the General Administration Department, GAD, Government of Orissa, informed the petitioner that as per a fielding report, government land had measured an area of 5 feet 6 inches, bracket approximately, into 68 feet, bracket AC 0.009, on the western side of the plot had been encroached within the boundary wall. Full stop. He was asked to intimate the department if he was willing to take single quotes permissive possession of the above land as per prevailing rules. Unquote. The petitioner by letter dated 15th March 2000 expressed his willingness. Full stop. However, as it transpires, the petitioner was unable to actually get permissive possession for the additional plot of land. Paragraph. On 17th, present round of proceedings were triggered by a show cause notice issued to the petitioner on 17 July 2012 by the BDA, stating that petitioner had undertaken construction of the house, G+2 stories, and AC shed house, open quotation, without leaving proper setback as per building regulations. Unquote. Full stop. In reply to the show cause notice, the petitioner contended that the building plan had been approved on 17th April 1974 and renewed from time to time, the last renewal being on 25th July 1980, and that all constructions over the plot in question had been completed prior to the enactment of the ODA Act. Stop. He claimed that, open quotation, all such actions have been duly saved and protected under Section 128 of the ODA Act. Stop, unquote. Claiming that Section 91 and Section 15 of the ODA Act cannot be applied to his case, he contended that the action initiated against him was entirely without the authority of law and should be dropped. Paragraph. On the said show cause, an order was passed by the OSD, ODA Act on 11/2012, noting inter alia that the petitioner was unable to produce the approved signed plan for the plot in question. Full stop. On the other hand, the letter dated 28th August 1973 of the chief engineer, bracket roads and building, showed that the approved plan contained a clear stipulation that no compound wall should be constructed and that adequate space should be kept vacant for police. Full stop. The order also referred to the field report, which revealed that a boundary wall had been constructed without leaving the minimum 5 feet setback. Further, it revealed that although the plot that was allotted was of the area 110 feet into 69.6 feet, the petitioner was in possession of a larger extent. Full stop. Accordingly, the petitioner was asked to remove the unauthorized construction. Full stop. Paragraph. As already noted, the appeal filed against the said order was dismissed by the impugned order dated 18th May 2013, where the contentions of the petitioner have been rejected because factually that he had not adhered to the conditions on which the original plan was sanctioned. Paragraph. Counsel for the petitioner, first of all, argued that in the absence of any counter affidavit by the opposite parties, the petition should be all the governments in the petition should be deemed to have been accepted and the petition should be allowed. Reliance is placed on the decision in Lohia Properties Private Limited versus Atmaram Kumar. 1993 4 SCC page 6. Paragraph, it is seen that the above decision was in the context of a civil suit and reference was made specifically to Order 8 Rule 5 bracket 1 CPC, which itself states that if a fact in a plaint is not specifically denied, then it should be taken to be admitted. Full stop. That is not the position here at all. There are two impugned orders staring at the petitioner, where the entire case against the petitioner has already been set out by the Full stop. It was in fact on the petitioner, the burden of the petitioner to show that those factual details on the basis of which the orders have been passed were contrary to what has been stated in the orders. Full stop. Consequently, in a proceeding of the present nature, where what is in challenge, under challenge is an order of a quasi-judicial authority based on facts, it is for the petitioner to demonstrate that factually those orders were wrong. Full stop. The petitioner has been unfortunately not been able to do that in the writ petition. Paragraph. Counsel, the petitioner next relied on the decision in Pratap Kumar Jena versus Government of Orissa, 2017 1 OLR 222, to the same effect about counter affidavit not being filed and therefore the petition having to be allowed. Full stop. Again, this decision is of no use, no help to the petitioner, since the petitioner has not been able to dislodge factual elements that form the basis of the impugned orders, which he has challenged which the petitioner has challenged in the present petition. Paragraph. As far as the legal argument about the applicability of the ODA Act is concerned, it is seen that the condition attached to the sanction order was violated by the petitioner. Full stop. Therefore, dehorsed the applicability of the provisions of the ODA Act. The fact remains that he neither left a 5 feet setback, as was the condition imposed in the letter, but also encroached upon the neighboring plot without actually getting provisional permission. Full stop. On both these counts, factually, therefore, the petitioner has no answer whatsoever. Full stop. In the circumstances, the court is unable to find any error having been committed by the authorities who passed the impugned orders which have been challenged in the present petition. This petition is without merit and is accordingly dismissed. No orders is to cause the interim orders vacated.
Supplementary list item number 4. Item 4.
None appears dismissed.
Item number 5.
May I please, Lord? Here, my lord, the respondent was an employee under the appellant, was taken retirement under VSS scheme. As per the regulation, there was a condition. The amount as per the scheme will be released only after it has cleared the dues outstanding against the corporation. Since that amount dues to the corporation that was not released, so the VSS scheme, that is amount due to under the scheme, has remained on withheld, my lord. Against that has filed the writ, my lord, and the honorable court learned single judge.
So, what is the amount which you withheld?
48,000, my lord.
You want to contest that now?
My lord,
have you paid that 48,000 or you have not paid it yet?
Is recovered from the employee. 48,000.
Have you paid back after the impugned order?
Yes.
Have you paid back that amount?
No, no.
Why not?
Because 48,000 is to be recovered from the employee. Since that has not been cleared by the employee and has not produced the no due certificate, so the VSS dues has not been released.
Now I'm asking you again for the third time.
Yes, my lord.
Pursuant to the impugned order of the learned single judge, have you made the payment or you have not made the payment?
No, we have not made the payment.
On what basis? Stay order in the writ appeal?
My lord, I have challenged that order in this present
So
appeal.
mere challenge is enough without any stay order being passed by the court.
Since my appeal is sub judice,
So you yourself give yourself a stay. Is there a difference between filing an appeal and getting a stay order and filing an appeal and not getting a stay order? Is there a difference between the two?
no difference, but since
There's no difference.
because I have challenged that matter is
So
sub
there is a
judice.
difference between filing an appeal and getting a stay order and filing an appeal and not getting a stay order. Is there a
Well, difference means since I have got chance of success in this appeal.
I'm astonished that you are getting
adjudicated and that is
arguments like this.
decided.
Even a third year BA LLB student will know the difference, sir. There is no difference between filing an appeal, not getting a stay, and filing an appeal and getting a stay. There is no difference.
But the implementer is from the side of the opposite party, he has to make a demand.
I see.
But he
Otherwise, you
remains-
don't have to comply with.
But he remains silent.
I see. So you don't have to be silent.
Yes, since I have taken the opportunity of appeal.
Amazing. Amazing. Yes, all right. All right. This is all new law. In fact, there's no end to learning. For us, I think it is a new learning for two of us as judges.
When the amount has been recovered from the employee, that has not been cleared, and they learn it on a single judge has.
How many years in the bar have you put, sir?
Only the
How many
amount
years in the
advance.
bar?
My lord,
How many years in the bar?
I have completed more than 30 years.
I see. So this is the law that you've understood. The minute you file an appeal, automatic stay.
But that doesn't I mean, but I the appeal. But I am interpreting the.
No, we are also
Single
learning. See,
judge.
we are also learning. So we are learning from you. So we should understand that the minute you file an appeal, there's an automatic stay.
No, I have not taken the stay, my lord. That I do admit, my lord. But my interpretation is that honorable single judge at paragraph 22 has interpreted it that due means only the advance taken, not any other dues. But once an amount has been determined and it's ordered that it should be recovered from his salary, so it becomes a due, not the advance taken. That paragraph 22, your lordship can have glance.
So date of the impugned order is 24th April 2015.
Yes, my lord.
7.5 years now.
Yes, my lord.
You have to pay 48,000 with 10% interest. Correct? You put 48,000, 10% interest, 7.5 years. What will the amount be occur to? I'm asking you a question, sir.
Yes.
What is the amount working out to?
10% interest rate would come to 480 plus 48.
What is the age of this man?
480.
What is the age of this man? He's a retired employee, correct?
The retired employee. Yes. He has taken VSS scheme, my lord.
So will this amount mean anything to him, sir?
Before reaching age of
Will this amount mean anything to him? Will this amount mean anything to him, sir? You've just withheld it.
After all, this is the
Despite an order against you by the single judge, you have not bothered. Even today, you'll be advising your client, sir, we have only filed an appeal, no problem. Don't do anything.
My amount is 48,000. He has to give some more. After deduction 48,000, if landlord will direct, I will release the amount.
This is all new laws for us. We are trying to learn from you. Unless we direct, we will not release. You've already been directed, sir, by the single judge.
I don't mean to say that you should have released the balance amount after deducting 48,000.
After deducting, he has gone and filed a
48,000 is
petition.
due to the corporation.
So you're remarkable, sir.
That is the due.
Because 48,000, he went in a writ petition. He succeeded in the writ petition. When I ask you, do you have to pay? You say, yes, after deducting 48,000, I will release. Anyway, yes. What else? What else do you have to argue, sir?
That's the only ground that interpretation of paragraph 22.
All right.
Paragraph 22 of the order.
All right.
It said that due means only advance taken from the corporation.
All right.
My submission, when the amount has been determined and it is an order to be recovered from the salary, it becomes due. Not the advance taken. When he is retiring from service, he has to produce no due certificate. There nothing is outstanding as the corporation.
Correct. The respondent approached the learned single judge. The respondent, a retired employee of the present appellant, approached the single judge with writ petition civil 26179 of 2011 for release of his terminal benefits after he opted for the voluntary separation scheme bracket VSS implemented by the appellant. Full stop. As it transpired, after accepting the VSS, the respondent was supposed to get a refund of rupees 48,000. Full stop. This amount was, however, not released to him on the ground that the respondent had not submitted a single quote no due certificate. Unquote. Paragraph. As it is evident from the impugned order, the appellant, despite notice in the petition, did not choose to file any counter affidavit. Full stop. The learned single judge then queried from the appellant what was meant by single quotes dues unquote lying with the respondent. Full stop. The reply of counsel appearing for the appellant before the learned single judge was that the respondent had been assigned the duty of plying a bus and had been asked to attain some target, but had failed to do so, as a result of which financial loss had been caused to the appellant to the tune of rupees 48,000. Full stop. The learned single judge has, and in view of this court, rightly, rejected this argument. Noting that the respondent had not taken any advance in cash from the appellant, which he had not returned to the appellant. Full stop. Merely not meeting some target would not amount to the respondent owing the appellant an amount, because at best it could be said to be a dereliction of duty or a misconduct for which there had to be some inquiry held. Full stop. In the impugned order in para 23, it has been observed by the learned single judge as under. Reproduce para 23, page 30. Paragraph. The learned single judge rejected the stand of the appellant that sum of rupees 48,000 was paid by the respondent. No due certificate could be issued. Full stop. Paragraph, having heard learned counsel for the appellant, this court is unable to take a view different from that taken by the learned single judge. Full stop. It appears that the appellant unilaterally decided that the aforementioned sum was due to the appellant from the respondent on account of his not meeting certain targets while plying the bus operated by the appellant. Full stop. It does not appear that any such that there was any inquiry or an opportunity to the respondent to meet the said demand prior to his retirement. Full stop. It cannot therefore be said that the amount was due by the respondent to the appellant. Paragraph. Before concluding this order, it must be noted that despite there being no stay granted by this court against the order of the learned single judge issuing a mandamus to the appellant to make the payment due to the respondent together with 10% simple interest, the appellant has made no such payment till date. Full stop. In other words, merely because it has filed an appeal, it assumed that it did not have to comply with the order of the learned single judge. Full stop. Further, as noted in the impugned order of the learned single judge, the appellant was also not paid his GPF and other retirement dues. Full stop. In the circumstances, the is dismissed with costs of rupees 10,000, which will be paid to the appellant along with the dues in terms of the impugned order of the single judge within 4 weeks. You see, the contempt case is disposed of with the above directions. You put down the contempt case on top itself.
Item number 6.
Item 6. Our name has not yet been reflected that Mr. H.M. Dhal and Associates, Lordship. We have for the appellant, Lordship. Lordship, the petitioner bank, United Bank of India, has been merged into Punjab National Bank, and we will file the amendment for.
What is the matter about, sir? You tell us. It's all waste of time. Tell us what the matter is about.
Challenging the single judge.
What does the order say?
Order. Lordship, Annex 13 is under challenge, Lordship. That is page 60. Kindly see page 80, Lordship. Compulsory retirement was allowed, Lordship. The allegation is there is some amount of 4,390 was transaction, Lordship. The petitioner, the respondent petitioner was the manager of the Aligonda branch of United Bank of India, and some irregularity transaction was made by him for the benefit bank, Lordship. That amount was 4,390, Lordship.
So what has happened pursuant to the impugned order of the learned single judge? Did you reinstate him in service, sir?
Allowed, Lordship.
Did you reinstate him in service? Did you give him all his continuity of benefits?
Lordship, I have no instruction, Lordship.
Then why are we entertaining this appeal if you have no instruction?
Lordship, 10 days more.
We are not adjourning, sir. The challenge of the present appeal is to an order dated judgment dated 1st December 2015 passed by the learned single judge allowing writ petition civil 9535/2008 filed by the respondent, whereby he had sought quashing of the order dated 30th November 2007 passed by the appellant, inflicting the punishment of removal from service which had been confirmed by the appellate authority by an order dated 25th March 2008. Paragraph. Among the infirmities that the learned single noted in the inquiry conducted, in the disciplinary inquiry conducted against the respondent was not incorporating the statement of the head cashier in the memorandum of charge, semicolon. Not providing the list of witnesses in the charge sheet, thereby depriving the respondent of an opportunity to cross-examine the said head cashier. Based on the punishment had been imposed of compulsory retirement on the respondent. Full stop. Further, the learned single judge noted that the evidence and record showed that there's no, in fact, no intention on behalf of the respondent to cause loss to the bank. And in fact, no such loss was caused. And therefore, the punishment of compulsory retirement was itself unjustified. Full stop. Having heard learned counsel for the appellate and having gone through the impugned order of the learned single judge, as well as the documents and record, the court is unable to come to a different conclusion. Full stop. In fact, if there are procedural lapses in the conduct of the disciplinary inquiry, then the entire inquiry gets initiated, as does the consequential punishment imposed. Full stop. There being no grounds to interfere with the impugned order of the learned single judge, the appeal is dismissed.
Item number 7.
Put down his appearance.
Well,
He's given his name. All right. HM Girls.
Item number 7.
None appears dismissed.
Item number 8.
That's item 8 and 9. Identical question. The delay is about 209 days.
All right. The delay has not been properly explained. Even certified copy has not been filed. For the appeals are accordingly dismissed.
Item number 10.
Permitted to withdraw, my lord.
Counsel, the appellant seeks leave to withdraw the appeal. Dismisses withdrawn.
Item number 11.
Lordship, in item number 11, the appearance of Mr. Gautam Mukherjee and associates may be deleted. We are no more the counsel.
Counsel states that they are no longer appearing for the appellant. None appears for the appellant. Dismissal not possible.
Item 11 minutes, I am appearing for Cuttack Development Authority minutes. My name may be noted.
All right.
Item number 12.
Item 12, the order has already been partly complied. Differential amount has not been paid. We will pay it within 10 days.
Counsel, the appellant states that the order under appeal has already been partly complied and a differential amount will be paid within 10 days. That view of the matter, no further orders are required to be passed. The appeal is disposed of.
Item number 13.
None appears dismissed.
Item number 14.
None appears dismissed.
Item number 15.
None appears dismissed.
Item number 16.
None appears dismissed.
Item number 17.
No instruction.
No instructions dismissed.
Item number 18.
None appears dismissed.
Item number 19.
School items. 19 में there is a delay.
Certified copy has not been filed for over 6 years. Remains unremoved. The appeal is accordingly dismissed.
Item number 20.
20 will also be infructuous.
Infructuous dismissed.
Item number 21.
Item 20, no instruction.
No instructions dismissed.
Item 22.
22, my lord, there is a delay of 1 month. It may be condoned, my lord. May I place the matter, my lord? My lord, the petitioner is working as a ASA within the from 10/9/2007. She was on medical leave. We date from 28/10/2014, my lord. My lord, she has joined after returning from leave. She submitted her joining report, which was not accepted, man.
Which matter is this?
22.
My lord, read appeal 345/2016.
Or delay is cut. Yes. Carry on, sir.
My lord, she's also submitted a representation to the respondent number 2 that also she moved in WPC number 8567 of 2016 under Annexure 1. But it was dismissed order dated 21/6/2016, my lord. The agreed she moved in this writ appeal. With permission, my lord, she was granted leave, my lord. to take care of her ailing husband.
You're over, sir? You finished your argument?
Ma'am.
All right. The present appeal is directed against an order dated 21st June 2016, passed by the London single judge, dismissing writ petition civil 8567 of 2016, filed by the present appellant. Questioning. An order dated 6th May 2016, passed by the Chief District Medical Officer, bracket CDMO, bracket Puri, by which the representation made by the appellant in terms of an earlier order passed by the London single judge and writ petition civil 4816 of 2015 was rejected by the CDMO. Full stop. The grievance of the appellant was that after she returned from her leave, which she had availed for looking after her ailing husband on 3rd February 2015, she was not allowed to work as an ASHA worker in Ganeshwarpur village under the Gop CHC, where she had been engaged since 10th September 2007. Paragraph. Admittedly, the appellant remained on medical with effect from 28th October 2014. Full stop. According to her, she had gone to attend to her husband who had sustained an injury in his right palm at his place of work at Surat. Full stop. What the learned single judge has found is that despite opportunities, the appellant could not produce any medical certificate or discharge summary regarding her ailing husband in order to show that her absence was bona fide. Full stop. She left all and remained absent from service for about 3 months. Full stop. The engagement as ASHA was purely contractual, and it was incumbent on her to have informed the competent authority before absenting herself so that he could make alternative arrangements. Full stop. Paragraph. As regards the leave application, the appellant claimed that she had not retained a copy of the leave application and therefore could not produce it. Full stop. The single judge has rightly observed that merely on an oral statement, the appellant's plea in this regard cannot be accepted. Paragraph. Having heard learned counsel for the appellant and having produced the impugned order of the single judge, the court is unable to find any error having been committed in dismissing the writ petition filed by the appellant. Full stop. This is a case where there is absolutely no document produced by the appellant to substantiate any of her pleas, either on proceeding on leave without intimation or about staying away for 3 months to attend to the medical needs of her husband. Full stop. Consequently, no error can be found in the impugned order of the single judge. The appeal is accordingly dismissed.
Item number 23. Item 23.
Lordship, 23, Lordship. In fact, Lordship, both the counts it in infractions, Lordship.
All right.
Sorry,
Infractions. Dismissed.
I was thinking 26, Lordship. Sorry.
Item
All
number
right.
24.
So 26 is also infractions.
I was thinking 26.
I see. 23 is dismissed as infractions. All right.
Supplementary item 20.
No instruction.
No instructions dismissed.
Item number 25.
None appears dismissed.
Item number 26.
None appears dismissed.
Item number 27.
None appears dismissed.
Item number 28.
None appears dismissed.
29.
None appears dismissed.
Item number 30.
None appears dismissed.
Supplementary item 31.
Delay.
This is a state table. There is also delay, my lord.
There's a delay of 482 days in filing the appeal, which has not been properly explained. Consequently, the application is dismissed. The appeal is accordingly dismissed.
Item 32.
None appears dismissed.
Item number 33.
None appears dismissed.
Item number 34.
None appears dismissed.
Item number 35.
My lord, my item was 25.
Mike, sir, Mike.
My lord, pardon me, lord. My item was 25.
25.
I pray, let me allow to argue the matter.
Yes, carry on.
My lord, this is the appeal against the order of the single bench.
What is the delay, sir?
My lord, deviations. Delay, my lord. Delay means 2 months.
404 days. There's a delay of 404 days in filing the appeal, and steps for limitation have not been taken for over 6 years now. The appeal is accordingly dismissed. Yes.
Supplementary list item 35.
None appears dismissed.
Item number 36.
The appeal is infructuous since it is post of as such.
Item number 37.
Item number 37, can you pass over?
Pass over.
Item number 38.
None appears dismissed.
39.
Milord, 39, Milord. Tata Power will be substituted in place of the appellant, Milord. Chesu. Milord, I pray for 10 days time to be substituted in place of.
So we're not adjourning, sir. You carry on.
Milord, that defect, Milord, that is the certified copy I am filing today, Milord.
You carry on, sir. Tell us what the matter is about.
Milord, the matter, Milord, though I have appeared, my name is not there. I am not fully prepared, Milord. I have filed the appeal and the connected case in which I am appearing. My name has not come, Milord, in the cause list, Milord. That is unfortunate, Milord. I got lost now. I traced it out. And Milord, the matter relates to that order of the single judge granting 2,000 as interim, 2 lakhs as interim compensation and directing to file suit, Milord.
Correct.
Milord, no, Milord.
Similar matter yesterday we have dismissed.
Milord, what happened, Milord?
Have you paid this 2 lakhs?
No, Milord, we have filed appeal, Milord. Milord,
sir, we'll amend the rules, sir. We'll amend the constitution also. Orissa amendment will pass. The minute an appeal is filed, automatic stay. Nobody needs to comply with the impugned order despite there being no stay.
Your Lordship may
we'll amend it.
Your Lordship may fix it in the local adalat so it can be settled, Milord.
I see, yes. Thank you. You're very considerate.
No.
For 6 years, this is some poor family, no?
No, maybe poor family. But death is not due to the coming in.
So you don't have to pay anything. Although the order is against you, you do not have to pay.
Order against me in the sense, Milord, the relying on a decision, Milord, where there was snapping of a wire and touching the snapped wire, the deceased died. In that case, that is admitted fact. So far this case is concerned, Milord, there is no snapping of wire, nothing was seized, nothing was happened on our plea, Milord. And as because he died on electrocution, the electricity company has been held liable, Milord. Milord, he may be died in his house or he may be died anywhere else after coming into contact with the electricity, Milord. But how can it be said that, Milord, we will be held liable? Milord, that decision is not applicable to the facts of circumstances of this case, Milord. Milord, what I pray, Milord, it may be called in the local adalat or any other day in your Lordship's court so that it can be settled in compromise, Milord. This claimant may be noticed, Milord, so that he should remain present and matter.
As it is, they are very poor people, sir. Let's not harass them even further.
Milord, we are ready. Milord, it will be settled within next week. Lordship may call it also.
All right. You see, the challenge in the present appeal is to an order dated 10th August 2016, passed by the single judge, disposing of writ petition civil 4908 of 2011, filed by the respondents, seeking compensation from the appellant of a sum of rupees 10 lakhs for the death of Bharat Dash, the husband of respondent number 1 and the father of respondents 2 and 3 due to electrocution. Full stop. The facts were that on 2nd August 2008, while the husband of respondent 1 was taking his cattle, he came into contact with a live electric wire snapped from the pole of the village road of Palapatna, as a result of which he fell down. They took him to the nearest medical center for treatment, but he was declared dead. Full stop. But he was declared brought dead. Full stop. Thereafter, an inquest was conducted and a report was submitted saying that the cause of death was due to electric shock. Full stop. Paragraph. The learned single judge has, following the decision in T. Bimala versus Cuttack Municipal Corporation, 2015, 1 OLR 637, and certain other decisions, directed that as interim compensation, the appellant should pay rupees 2 lakhs within 2 months and left it to the respondents to work out the remedies in other appropriate fora for higher compensation. Paragraph. As it transpires, having filed the present appeal, the appellant presumed there was an automatic stay of the impugn order and has not made payment of even a single rupee to the respondents till date. Full stop. It must be mentioned here that there is no order, interim order staying the impugned order of the learned single judge till date. Full stop. In fact, the appeal got listed today in its usual turn. Full stop. Be that as it may, the court finds that the learned single judge has balanced the equities, and while only granting some minimum interim to the respondents in the circumstances outlined here and before, relegated them to other appropriate remedies in accordance with law. Full stop. Having heard learned counsel of the appellant, the court is not satisfied that any case has been made out for interference with the impugned order of the learned single judge. The appeal is accordingly dismissed.
Milord, the T. Bimala case is not at all applicable. Milord, what happened in T. Bimala case, Milord, where was snapped in a drain, Milord. The sweeper, while cleaning the drain, he came in contact, Milord. There is admission of snapping of wire and death is due to electric shock after coming in contact with that electric wire, Milord. Here, Milord, there is no snapping of wire, nothing was detected, nothing was seized, Milord. As because he died on electric company will be held liable, Milord. That is my submission, Milord.
Nana is dismissed.
Item 41.
41. Just sorting is yield, my lord. Last night, your lordship. Any other remedy taken?
What's the matter about? What is the matter about, sir?
My lord, here is prepare, my lord. Short date may taken, my lord. He jail last night.
Days. Delay is 174 days.
Last night he was jail, my lord. Suddenly.
It was already delayed. Condoned. Counsel of the appellant is stated to be unwell. List on 15 November.
Item 42.
May I please, my lords? My lord, there is a delay. The impugned order single judge passed on 22nd June, and the appeal was filed in September. The ground taken, the ground is that the appellant was not present.
It's all right. Tell us now. The delay is condoned. Tell us what the matter is about.
Matter. The entire question is, my lord, the 8 years of service he served on the National Coal Development Corporation, and Agriculture University wanted to an experienced person with service experience. He applied for that post, selected in 78. Only prayer is his service under those earlier corporations should be counted for pension, subject to refund of the gratuity and pension given to the that I have given. The single judge rejected the case only on the ground that I had to resign in the NCDC and come here, Coal India. That is the only ground. That's why I have resigned. And that is formality. Unless I resign, how can I come here? I was under the That is the thing.
That's correct only, sir.
8 year service has been
Can't be helped. But it's a clear break in service once there's resignation.
Well, that is my own son. There are rules in the statute of the university and the state government notification.
It is not by deputation. There's an advertisement, you applied afresh, you got a new job, you resigned, then took the new job. So where's the question of continuity in service? That won't be. The challenge in the present writ petition is to an order dated 22nd June 2016, passed by the learned single judge, dismissing the appellant's writ petition civil 9531 of 2009. The prayer in the writ petition was for a direction to the Orissa University of Agriculture and Technology, bracket OUE, to count the service rendered by the petitioner at the with the National Coal Development Corporation Limited, bracket NCDCL, bracket from 3rd March 1970 to 14th November 1978 towards qualifying service for the purposes of gratuity, leave, salary, and pension. Paragraph. The appellant was initially appointed as a horticultural inspector in the NCDCL, a Government of India undertaking, by an order dated 9 January 1997. Was serving as such, the OU-AT issued an advertisement for post of research officers. Full stop. He applied to the proper channel and was appointed by an order dated 21st September 1978. Full stop. Admittedly, the appellant tendered a resignation from NCDCL, which was accepted, and thereafter he joined OU-AT as a research officer on 15 November 1978. Full stop. Paragraph. The learned single judge has found that since the appellant had applied for a new post pursuant to advertisement and had in fact resigned from the earlier post with the NCDCL, he could not claim continuity of service or counting the period of service rendered in the NCDCL towards for the purposes of his retirement benefits. Full stop. The above position in law is unexceptionable, and the court is unable to find any error having been committed by the learned single judge. The appeal is accordingly dismissed.
Item number 43.
May I please, Your Lordship? Your Lordship, I am for the appellant appearing on behalf of Your Lordship. This matter is pertaining to OCH PFL Act, Odisha Consolidation of Holding and Prevention of Land Fragmentation Act. Your Lordship may kindly see Annexure 2, page 15. What has happened, Your Lordship? The current respondent number 2 has filed a revision case in 1968, which was dismissed for default in 2007, 21/9/2007, Your Lordship. And the party goes into slumber after 7 years, awaking and filing a restoration petition. Your Lordship may kindly sue Annexure 2 without filing a proper petition under Annexure 2 for restoration, without filing an affidavit and wakalatnama. Neither filed and limitation showing sufficient cause of delay. They filed this frivolous petition, and the restoration was allowed by the learned consultation commissioner, Your Lordship. We challenge this before the Honorable Single Judge, Your Lordship. Honorable Single Judge failed to appreciate the fact that only on the ground that it was mere technical. But I should say that the adherence to the legal formalities is one of the main criteria, Your Lordship, that they cannot file just a frivolous petition without a proper petition for restoration and for the limitation also. So there is a difference between inordinate reasonable delay, Your Lordship. There was 7 years of delay. They didn't file a petition for limitation and couldn't show any sufficient cause to restore the petition. Apart from that, one more important aspect what is to be noted down, notice to Your Lordship, there is a civil suit after it was dismissed, after the revision petition was dismissed in 2007 and 2008. The current appellants have filed a civil suit which is pending before the Civil Judge Senior Division Bargad, which is the matter of the dispute, that is the scheduled land in the suit is similar to this current revisional, the current land which is challenged in the revisional petition, Your Lordship. So when there is a civil suit, the civil court has assumed the power of deciding the right title interest of the property of the parties in the civil suit. The consultation proceeding should not be initiated. So there cannot be two recourse, Your Lordship, that the civil suit is pending and they have filed their WS also in that civil suit. So there cannot be two recourse, and after filing of civil suit, that they cannot say that we once again want to go for a revision in consultation proceeding, Your Lordship.
All right. Nobody's appearing for the respondent. All right. The challenge is the present appeal is to an order dated 15 September 2016 passed by the single judge, dismissing the appellant's writ petition civil 12994 of 2015, whereby the appellant had assailed an order dated 23rd February 2015 passed by the Additional Commissioner, Consolidation and Settlement, Sambalpur. Full stop. The paragraph. The learned single judge has... No, you say the aforementioned order had been passed by the Additional Commissioner, Consolidation and Settlement, recalling an earlier order dated 21st September 2007, whereby consolidation revision case number SAM 833 of 1988, bracket old number 1655 of 1986, dismissing the case for default, was recalled. Paragraph. Admittedly, the recall application was filed more than 7 years after the case was dismissed for default. Full stop. The learned Consolidation Commissioner appears to have allowed the recall application only because notification under section 41 bracket 1 of the Act had not yet been published. Full stop. A perusal of the impugned order of the Commissioner reveals that no reasons in particular have been given for entertaining the application for recall, 7 years after the dismissal in default was passed. Full stop. It is incumbent on the Commissioner to have asked proper justification for the inordinate delay. Full stop. Paragraph. The learned single judge appears to have viewed the above delay as being merely technical and therefore has declined to interfere with the impugned order of the Commissioner. Full stop. The court, on the other hand, is of the view that this court, on the other hand, is of the view that the delay being inordinate, it was incumbent on the to offer a proper explanation. Paragraph. Secondly, it is pointed out by learned counsel for the appellant that there is already a civil suit pending between the parties in relation to the same parcel of land, in which the opposite respondent has appeared and is contesting the suit by filing a written statement. Full stop. This is another ground why the Commissioner ought not to have entertained the recall application to revive a revision petition concerning the same subject matter. Paragraph. For the aforementioned reasons, the impugned order of the learned single judge is hereby set aside, as is the order dated 23rd February 2015 of the Additional Commission Condition Settlement. We'll stop. The writ appeal is allowed in the above terms. No orders is to cause.
Item 44.
None appears dismissed.
Item number 45.
May I please, Your Lordship? Now, the appellant has preferred this appeal against the order dated 13/9/2016 passed by the learned single judge, my lord. Well, kindly have a glance at Annexure 5, my lord. The order which is under challenge, my lord, page 36. Let's may come to page 39, my lord, the operative part of the order. In course of hearing, when a query is made as to the validity of the select list, learned advocate for the petitioner as well as the learned standing counsel for the school and mass education submit that the select list was valid for 1 year. The select list is not a permanent reserve that whenever in future vacancy will arise, the same would be filled up from the waiting list. In the instant case, the select has
The select has outlived its validity. In view of the same, no case is made out to interfere with the order dated 1/5/2015 passed by the collector cum CEO Jilla Parishad Puri, opposite party number 3. The petition is dismissed. Lordship, kindly have a glance at the order dated 1/5/2015 cum CEO Jilla Parishad Puri under Annex 2, my lord. That is page 15. Lordship, we come to page 16, my lord, the operative part of the order, my lord. Heard both parties and verified all relevant documents with annexure filed by the DPC SSA in his case record. I am of the opinion that the petitioner has not secured more marks than the 17 number of city candidates court appointment, but this process of engagement of Sikha Sak is now under sub judice before the Honorable High Court. The stay order is in force and it is not proper to interference with the engagement process of Sikha Sak relating to ST backlog vacancies, since the selection process itself is questioned before the Honorable High Court. Hence, the it cannot be considered. She shall act as for the result of the Honorable High Court in future, my lord. My lord, this writ appeal, my lord, who is the DPC has referred to, my lord, still is, my lord, pending. My lord, this is sub judice, my lord.
Okay, sir, if you've not got more marks, then no point.
My lord, vacancies are there, my lord.
No, then you've already been given liberty to act as per the result of the High Court order.
My lord, vacancies are there. My lord, I am at the serial number 1.
Await the pendency, then that petition is still pending, correct?
Yes, my lord.
So you await the outcome of that, sir. This order is not wrong.
I am standing in the waiting list 1, my lord. Vacancies are there. 2 vacancies are there.
No, but everybody is waiting, sir. That appointments have not still materialized because the writ petition is pending.
Lordship, that writ petition may be tagged along with this.
No. You see, the challenge of the present petition is to an order dated 13 September 2016, passed by the single judge, dismissing writ petition civil 11538 of 2015, filed by the present appellant. Paragraph. In the said writ petition, the appellant had questioned an order dated 1st May 2015 of the collector cum CEO Jilla Parishad Puri, rejecting her representation for appointment to the post of Sikya Sahayak. Paragraph. A perusal of the order dated 1/5/2015 reveals that the reasons that weighed with the collector for rejecting the plea of the appellant was as under. Reproduce page 16, last paragraph. Heard both parties up to in future. Paragraph. Counsel for the appellant points out that the aforementioned writ petition in this court is still pending.
Yes, my lord.
So with that view of the matter, the interests of the appellant have already been protected by the above order by giving her liberty to revive her plea to the outcome of the writ petition. Full stop. No other order could have been passed in the circumstances. Accordingly, the court finds no ground to interfere with either the order of the collector or of the single judge. Writ appeal is dismissed.
Item number 46.
Permitted to withdraw, my lord.
Counsel for the petitioner. Appellant seeks leave to withdraw this appeal. Dismisses withdrawal.
Item number 47.
None appeals dismissed.
Item 48.
None dismissed.
Item number 49.
None appeals dismissed.
Item number 50.
None appeals dismissed.
Item 51.
Item 51, Lordship, this appeal is arising out of a Gram Panchayat election case. The tenure is over, the matter become infructuous.
Counsel for the appellant states that the appeal has been rendered infructuous. It is disposed of as such.
Lordship, the issue may kept open is a surplus disqualification matter under section 25(1)(b) of the Odisha Gram Panchayat Act, Lordship.
We've already passed the order. It's infructuous. All right.
Item 52.
My lord, I am permitted to withdraw. Your lordship may grant liberty to approach for getting financial benefits.
Counsel for the appellant seeks leave to withdraw the present appeal with liberty to approach the authorities for financial benefits, if any, without expressing any view on the contention of the appellant. The appeal is dismissed as withdrawn with liberty is granted.
Item number 53.
May I please, your lordship? It is a case, lordship, against the order of the honorable single judge dated 27/9/2016, lordship. Case of selection for the post of Anganwadi helper, lordship. As per the advertisement, Annexure 1, Annexure 2 is page 12 is the procedure of selection, lordship. Page 12, lordship. Government instruction, lordship. 3 members are there. One is chairperson, that is CDPO. supervisor in charge of area, and A&M, your lordship. In the selection procedure, they made that page 16B, your lordship, that is the only CDPO and supervisor, both the supervisors. Thereafter, I came before a lordship, and lordship directed to give a representation to the SD sub-collector. They'll pass the appropriate order, your lordship. In view of this honorable court's order, Annexure 6, page 20, the sub-collector has passed the order, turning page 21, that the CDPO Ranpur is directed, after passing the same, CDPO Ranpur is directed to take up the matter afresh, convene Mahila Sabha in the village, offer both the respondents and appellant the opportunity to offer their candidature in case voting takes place. It should be recorded clearly and under camera, and engagement order should be issued in favor of the candidate who is secured the highest number of clear votes in the Mahila Sabha, lordship. Taking to that order, sub-collector's order dated, that is the 2015 challenge before the single bench, that is order dated Annexure 8, page 33, your lordship. Though I have taken the stand before that opposite number 4, turning page 37, Mr. Dawai, Reverend Counsel for the opposite party, number 4 submits that there was no valid meeting. That is the one that the member is not there. The procedure of the meeting has not been recorded accordingly to the circular issued by the state of Odisha. 3 persons shall remain present along with CDPO. The Asakami was absent in the meeting. In view of the same, the resolution is made in law. Selection of the petitioner is not in accordance with the circular of the government, lordship. Taking into consideration, they passed the order in favor of the lordship. There is a without valid, as for the resolution of the government, 3 members should have been there, lordship. The supervisor, one A&M and CDPO. Both the members are present, CDPO and supervisor. Instead of A&M, they've combined the lady supervisor, both the lady supervisor in the committee.
There's no interim order here, sir. That woman is continuing then.
Yes, yes, continue.
How many years has she continued?
Since 2011.
More than 10, 11 years now.
Because it is infraction of the government guidelines.
All right. The appeal has been filed against an order dated 27th September 2016, passed by the single judge, allowing writ petition civil 13250 of 2015. Filed by respondent number 4. Full stop. The above writ petition had been filed respondent number 4, challenging an order dated 17 June 2015, passed by the sub-collector Nayagarh, allowing AWC miss appeal number 4 of 2013, whereby the appointment of respondent number 4 as Anganwadi helper was set aside. Stop. Paragraph. The respondent before had been selected as Anganwadi helper in the Benta 2 Anganwadi Center in Nayagarh. Pursuant to a Mahila Sabha held on 10th August 2011. At the meeting, all the members present cast their votes in favor of respondent number 4. Paragraph. The present appellant filed AWC miss appeal number 4 2013 before the sub-collector, which was allowed by the sub-collector, setting aside the order dated 23rd September 2011 engaging respondent number 4 as Anganwadi helper. Full stop. The matter was directed to be taken up afresh by convening a Mahila Sabha in the village. Paragraph. The allegation by the present appellant was that at the meeting convened to select respondent 4 as AW helper, there was no meeting. There's no voting. And therefore, the resolution appointing her as AW helper was not in accordance with the procedure, prescribed procedure. Full stop. Paragraph. For the learned single judge, the additional government advocate produced the meetings of the register, the proceedings of the Mahila Sabha register. The learned single judge noted that the respondent 4 had been selected by consensus and the proceedings had been signed by the CDPO Ranpur as well as LS Ranpur. Full stop. Since the selection was by consensus, there was no occasion to go in for a vote. Full stop. Paragraph. Indeed, it appears to this court that respondent 4 was selected by way of a consensus. Full stop. There was no occasion to take the decision by way of a vote, and therefore the proceedings did not record any such voting. Paragraph. No illegality appears to have been committed in the selection of respondent 4 as AW helper. There are no grounds made out to interfere with the impunity of the learned single judge. The appeal is dismissed.
Item number 54.
The petitioner is the grandson of this one Arjun Rohidas matter. And your lordship kindly recommend to page 15 matter. He filed a revision before the Survey Settlement Authority, Additional Commissioner of Settlement matter, and consultation before the Sambalpur as per page 12 matter. By RP case number 931/2014, page 12 matter. He filed a revision petition application before the consultation or commission, additional commissioner. And the commissioner matter directed the Tahsildar to give a paravised comment. Page 15 matter. Annexure 2.
The revision petition after 38 years, sir.
Matter. This petition is the grandson matter. This is lease case number. My read matter report of Tahsildar. One Arjun Rohidas, son of Purno Rohidas of village Leimal, was granted lease over the mentioned scheduled land in Sambalpur Tahsil in lease case number 2010 of 1979. The field verification report, Revenue Inspector Lapanga, reveals that the petitioner of the RP case, Sachidananda Rohidas, son of Thakur Rohidas, is the possession of the suit land. Late Thakur Rohidas is the son of Arjun Rohidas, as revealed from the inquiry made by the Revenue Inspector Lapanga. The suit land, Hamis Kata number 179, slot number 2661, 1.60 of village Bamaloy, corresponding to major Khata number 198 AJ out of plot number 576 is from Potito, then area of 1.60 of Mauda Tileimal, presently declared in government Khata, and the petitioner had not applied for grant of Patta in his name of HS plot number 3237 under Khata number 179 of Mauda Bamalay. But the petitioner is in cultivable possession of the land. He has not applied for settlement land in the major settlement matter. That is his fault.
So come to the revision petition order.
Mallet.
Additional commissioners.
Yes, but I am reading this order, Mallet. The instant revision petition was...
No, don't start from the beginning, sir. Come to the operative portion.
Yes, Mallet. From the
above discussion, it is clear. The petitioner's grandfather was never in possession.
Mallet, the fact that why has it matter? Your lordship will kindly see the next one paragraph above. The Tahsildar Lengali has also submitted a original lease case number as the perusal of the case record reveals that the lease sanctioned by the Tahsildar has not been approved by the. Therefore, he has settled like this.
Yes, correct. What's wrong with that?
Mallet, he due to ignorance of his.
No.
That is
no ignorance, sir, please.
Mallet, my one thing, Mallet. The Tahsildar has to recommend when the Tahsildar.
You have one more problem, sir. Come to page 13.
Yes, Mallet. 13.
Page 13.
13, Mallet. The petition also in and No, my lord, it is not correct, my lord. Lordship will kindly see the genealogy given by the RI, my lord. At page, my lord. That is page 17, my lord.
Yes.
My lord, this Arjun Rohidas is admittedly the grandfather, my lord, of the petitioner, my lord. And this Thakur Rohidas is admittedly his father. The other branch is Brunda Rohidas, they are not occupying the land. It is a government land, my lord. And it is not, it is their ancestral land, so that they will get a share. Accordingly, they say he is giving false statement. There are other members. And admittedly,
that's only one of the grounds anyway. Yes.
Your lordship will kindly see the RI has categorically stated this petitioner is in cultivating possession shows to the Tahsildar that the petitioner is cultivable possession of the suit land, man. Admittedly, it is written by the Tahsildar, man, at page 15. Since along from the date of possession of his grandfather period, after grandfather, his father was possessing, then this petitioner was possessing the land, and nobody else is there. It is a government land. It is not a royalty land, so that other co-sharer will get share. Man. The only question is, it is the duty of the Tahsildar to submit the lease case to the supplemental for confirmation for preparation of pata matter. But the Tahsildar has not done that. He has only granted lease and remained silent. And this thing is not known to this petitioner's matter.
We filed a revision petition after 38 years. Very long time.
How this thing come to the knowledge of the petitioner?
38 years. Please.
After 38 years, he has invoked.
No question. No question. All right.
So
that challenge the present petition writ appeal is to an order dated 16 September 2016 passed by the learned single judge dismissing writ petition 9 of 2016 filed by the appellant. Paragraph in the above writ petition, the appellant had challenged an order dated 11th May 2016 passed by the Additional Commissioner of Settlement and Consolidation (AC) Sambalpur in RP number 931 of 2014. Paragraph. The learned single judge noted that the revision petition itself had been filed by the petitioner after long lapse of 38 years and was therefore barred by limitation.
My lord, your lordship, kindly give me leave, my lord. I'll approach the Tahsildar for
No. Let it come to an end here, sir. Otherwise, more rounds of litigation. Further, the prayer of the petitioner was essentially for a direction to settle the land, settle land in his favor, which was beyond the scope of Section 15 bracket small b of the Orissa Survey and Settlement Act 1958. Stop. Having heard learned counsel for the appellant, the court is of the view that there is no error to be found in the inquiry order of the single judge. Paragraph B. Appellant has no answer to the no convincing and reasonable explanation to offer for the inordinate delay of 38 years in filing a revision petition, seeking the above directions. Stop. On that short ground itself, the learned single judge was justified in dismissing the writ petition. The court is unable to find any error having been committed in passing the above order. The writ appeal is accordingly dismissed.
Supplementary list item 55.
None appeals dismissed.
56.
Same order.
Item 57.
None appeals dismissed.
50, 59, 60 already. Supplementary item 61.
Delay.
61 has a delay of about 500 odd days.
There's a delay for 500 days filing the present writ appeal. No satisfactory explanation has been offered for the inordinate delay. The application for condition is just accordingly appeased. 625 days.
Item 62.
None appeals dismissed.
Item 63.
Item 63, 511 days delay. Both
the delay of 511 days of filing the appeal.
64 also.
Same, 64 also.
Item number 65.
65, my lords. Order dated 28th September.
It's already adjourned to 9th November. Somebody must have mentioned it in the morning.
I don't have any problem because that
The PSG, Mr. Padis mentioned it in the morning.
That is 65, Your Lordship. That is the PIL with
no,
regards to
the tagged up matter is one more case.
I know. Yes. So they wanted more time to respond. He says treatment is being given.
Lordship, actually, what he's trying to state is that they have filed another writ petition for some other kids.
One more case.
One more case.
That's not come up today.
Yes, my lord, that is there.
That is tagged along with my.
That's right. No, there's an earlier petition. This 14289 is the first petition.
That is
yours
mine,
is
Your
the
Lord.
second.
That is my.
Yours is first. This is the second petition, 25501.
My lord.
And now there will be a third petition.
No, my lord. This 255.
Right. Both these have been adjourned to 9th November.
9th November, Your Lordship.
And they will, what is that? The treatment, I'm just placing
that's
that
already
in terms
that's what he said.
in terms of your lordship's direction dated 16th September, that the same benefit be extended.
Right.
That's
in
not
25501 of 2022, the same treatment that has been directed to be offered by this court in its order dated
16th September.
16th September 2022 in writ petition civil 14289 of 2022 be extended to the present petitioner as well. List on 9th November 2022, the date already fixed.
Obliged.
Item number 66.
May I please the Lord? My Lordship, this is the PIL in which the CBS...
Where is that report?
Lord, I filed an IA in which I have attached the report
All right, let's just see that.
as annexation number 10, which is in page 37. My Lordship, as a part of the survey, the goal was to come up with a list of, an exact list of students who have been aggrieved. But while we were conducting the survey, it was a twofold survey where the petitioner visited 5 CBSE-based schools in Bhubaneswar, and the other one was an online survey which was conducted using Google Forms, and it was circulated to student groups by which they participated and entered their responses. Well, a part of the survey, which was the school visit, in that one, there were several challenges which came out in the forefront while we were conducting. One of which was, prior to that, we spoke to the principals, teachers, and some of the students of these schools. And the major part that came to the forefront was that these teachers or the schools were not even consulted before CBSE decided to make this change in marks weightage. The second part was the term 1 marks were shared with the students. The term 2 marks, the individual marks was not known to the students. So when we went and asked the students whether they have secured better in term 1 or term 2, some of them were not even able to answer because the term 2 marks came as a consolidated mark of term 1, 2 along with the practical marks. So most of them were not even aware. And if you have to be aware, then you have to pay a certain fee and get it from the CBSE. Apart from that reduced the number of students who came up as aggrieved. So those students who actually got their marks from the CBSE, they were the ones who came to us saying that we are aggrieved by this change in marks weightage. Apart from that, my lordship, the parents and some of the students did not even change in criteria. So many of them didn't even know that there was the 50-50 has been changed. So that resulted in a large number of students who felt like my lordship had rightly pointed out in the last date that there is a bell curve. Some would fall out of it. But in that case, the majority who are falling within the curve are the ones who do not even know whether they secured better in term 1 or term 2. And my lordship, while during this time, a very important judgment of the Delhi High Court came to light, which was in a similar case where one of the students had approached the Delhi High Court for a change in her marks weightage because she did not get selected in a particular college, less than 75%. Well, that judgment also I have attached in this IA as annexation number 9. And para 31, 32 and 33 of the judgment are very important, which is in page number 32, my lordship.
Yes.
Lordship, the Delhi High Court has clearly observed, should I read out the para 31?
All right.
Officer of the CBSE was present during the hearings before this court and assisted this court on the query made by this court for the approval of the minutes of the committee meeting, which has been placed on record, the concerned officer responded that the same has been approved by the competent authority of the board. Upon not finding any formal order by the competent authority enforcing the recommendation regarding the new weightage formula, this court was constrained to summon the original file which was furnished by the concerned officer. However, it was disappointing to see that only 2 green-colored sheets containing the notes of the controller of examinations was present, and no such order made by the chairperson or competent authority accepting, enforcing, and notifying the recommendation regarding the new weightage formula was present in the file produced. My lord, even in 32, para 32 and 33, they have...
Just see page 40, para 40. That's the most important thing. This answers what I was asking you earlier. See, unless the aggrieved person comes forth, otherwise this chaos will result. Just come to para 40.
Yes, my lord,
that's why the judge stopped of quashing the circular. He gave relief to this one individual student by restoring the earlier weightage, but said that I'm not going to quash the circular because it will result in chaos.
Yes. No, CBSE has created
14 lakh students.
14 lakh students, my lord. And even after going through this, even my, which was to scrap off the weightage formula, even I...
So even now, do you have a list of aggrieved students?
My lord, if the aggrieved students can directly approach the CBSE or they come up, like whenever any policy that is deviating, they can come up with a grievance.
It's possible then to show the Delhi High Court judgment and get relief for those students. That may be a better thing to do rather than undertake this exercise of upsetting the entire thing.
My lord, but they need to come up with a grievance redressal mechanism. Like
no, but do we have students who are really aggrieved? That's the whole point.
My lord, I have a list of the survey, the online survey which we circulated. It was filled up by 2,000 students, but many of them even filled up from outside Orissa.
No, will they be willing to come forth? See, many of them may not be interested in contesting all this, getting into litigation. They may have organized their lives. They must have already been pursuing other courses.
Yes, my lord.
So we shouldn't invite people to litigate when they're not interested in litigating.
But these set of students are interested. There are many.
No, which are these set of students? How many students do you have?
2,000.
Have they filed affidavits or are they filing an application to get impleaded?
No, my lordship, they have not filed an application.
We should not undertake an exercise when we don't have actually aggrieved people before us. Otherwise, it will result in huge chaos.
My lord, as students, they are scared that what if...
What is scared? This is only about challenging a criteria. What's the cost of getting scared?
But when we are circulating a survey, they are coming forward and talking about
that. Is different. If you ask them, do you wish to go to the court to challenge this? What is their answer? That's the question.
The answer is because they are not sure what is the relief.
Exactly.
Now, because they are not even aware of what is the relief
so
they
which
can
is
get.
Why the PIL is not the best recourse for these kind of issues. If there's a really aggrieved student, like it happened in the Delhi High Court, that student will go pursue the remedy and get the relief. That's the correct way to go about these things.
Lordship, but in such a case...
We'll note the fact that you've cited the judgment of the Delhi High Court, and we say if there are individual students who are still aggrieved, they may come forward to seek appropriate remedies. I think that's the best way.
But CBSE is not directed to come up with a scheme for these students, at least for those who approach them.
No, but we don't have an aggrieved party before us. We don't have an aggrieved student before us.
So the list of students who have filled up the survey, they have given all their details.
No, but we shouldn't presume that they want to come and become petitioners before us. We should not presume that if they've not actually come before us.
But my prayer is some step may be taken to at least...
We note the fact that the Delhi High Court has granted this relief to an individual student and say that other students can take advantage of that if they wish to.
They can always go and appeal against that order. But my point is observation.
We don't know whether they've gone and appeal or not. Since you've not found out about that, you're citing only the single judge's order. We should presume that this order is still undisturbed.
Lordship, one observation which the Delhi High Court has made, that may be reflected because...
But then we'll have to also quote 40, para 40.
Yes, my lord. The situation is very muddy. Even I'm saying that scrapping of the entire thing will result in a lot of students getting affected.
Correct.
But the aggrieved students may be given some relief in this case.
Let's see. All right. See, the present public interest litigation has been brought forth by the Odisha Abhibhavak Mahasangha, questioning the criteria adopted by the Central Board of Secondary Education, (CBC), of shifting the weightage between the term 1 and term 2 examination held by schools covered by the CBSE system. During the period of the pandemic, which saw complete closure of schools during November and December 2021. Full stop. The weightage has been shifted from 50s to 50 to 30s to 70, is it?
Yes, my lord.
In other words, CBSE decided by means of a circular dated 31st March 2022 that 30% weightage would be given to term 1 marks and 70% weightage to term 2 marks. Full stop. Paragraph. On an earlier occasion, this court had queried to learned counsel for the petitioner whether the changed criteria adversely affects all the students uniformly, or whether it would affect only one section of the students who may not have scored sufficient marks in either term in order to be adversely affected by the changed criteria. So, counsel of the petitioner then offered that the petitioner organization would itself conduct an empirical study to ascertain the factual position. Paragraph. Pursuant thereto, IA number 13684 of 2022 has been filed by the petitioner, inter alia enclosing with the application copy of the results of a survey conducted by the petition organization. Full stop. Fact of the matter is that the petitioner has ascertained that there may be a section of students who will be aggrieved by the changed criteria of the CBSE, but the petitioner organization has not been able to persuade such students to come forth to implead themselves as petitioners. Full stop. Counsel of the petitioner candidly states that those students may be apprehensive of what the result of such challenge might be. Paragraph. Counsel of the petitioner has also drawn attention to the court to a judgment dated 26th August 2022 of a learned single judge of the High Court of Delhi in writ petition civil. One 1775 of 2022 bracket Devashri Bali versus CBSE bracket, whereby relief was granted to the individual petitioner by issuing directions to the CBSE to declare her result in terms of a previous circular dated 5th July 2021, which provides for the special scheme of assessment mandating equal weightage to the theory papers for term 1 and term 2 while computing the result. Paragraph. Learned counsel, the petitioner has drawn attention of the court to the following passage in the said judgment, which is reproduced para 31 of page 32 of the judgment. The court nevertheless observes that in para 40 of the same judgment, the learned single judge of the Delhi High Court has observed as under reproduced para 40, page 35. Paragraph. In the above circumstances, with the actually aggrieved candidates, students not being prepared to come before this court as petitioners, this court is not inclined to entertain the present petition, its current form, as a PIL. Full stop. Nevertheless, aggrieved students Nevertheless, it will be open to the aggrieved students, if any, to seek relief in appropriate proceedings by relying on the aforementioned judgment of the Delhi High Court, if it is not in the meanwhile been interfered with in appeal. Full stop. The petition is disposed of in the above terms.
Lordship, can they at least appear before the CBSE directly if that may a time?
In other appropriate proceedings, including approaching the CBSE. All right. All right.
Supplementary list item 67.
Let item 67 have read for some other day on behalf of Mr. Mishra.
What's the matter about?
I don't have file. He's suffering for ill, my lord. So kindly some other day.
The encroachment.
Remove illegal unauthorized encroachment.
The encroachers.
But the encroachers have not been made parties. You have to give the encroachers a chance to be heard, sir. Have they named the encroachers at least in the representation?
No.
Is the annexure 2? That's the representation.
Whereas they haven't named encroachers.
Although the grievance of the present petition, as well as in the representation dated 19th April 2022, is that there are certain illegal unauthorized encroachments on both sides of the village road of village Kuanrpur. How do you spell it? Kuanr. Kuanrpur.
Kuanrpur. Kuanrpur. It's called Kuar. So
Kuarpur. In the district Baleshwar, the court finds that neither in the representation nor in the present petition the names of the alleged encroachers have been set out, much less have they been made parties. Full stop. Consequently, the court is not in a position to entertain the present petition. Nevertheless, it will be open to the petitioners to file a fresh representation with the authorities.
My lord, let it come, my lord, next week.
In fact,
naming the encroachers, and after following up on such representation to seek appropriate remedies in accordance with law.
in fact, the deputy collector, my lord, if sees annexure 3, the deputy collector has instructed the Tahsildar to look into the matter. So there has been some movement.
I know, but unless you name people, what is that looking into? It will not result in any. All right. Petition is disposed. Right.
Supplementary list fresh settings item 68.
Item number 68, I am permitted to withdraw.
Counsel, the petitioner seeks,
Both the appeals.
Seeks leave to withdraw these appeals. Dismiss is withdrawn. All right.
Item number 69.
May I permit it, please, my lords. Item 69 to item number 69 to 73, similar also follow. Here is a dispute concerning mutation manual as well as Orissa Servants OSS Act when the rules made thereunder. Now, the appellants have called in question the order annexure A passed by the Honorable Single Judge in writ petition 18,207 up to 22. Now, the quintessence of the order is that the quasi-judicial authority like the sub-collector has no jurisdiction to examine the validity, correctness, and whether an instrument is a fraudulent one or not. So he has exceeded his jurisdiction and passed an order, which has been challenged by the writ petitioners. Originally, by the Honorable Single Judge has observed, we have no dispute with regard to the principle of law. And my sole contention is that the disputed parcel plan relates to deed number 1249. But the mutation order has been passed in respect of deed number 1274, which is a registered power of attorney. It's not a cell deed. And that the original, the deed number 1249, which is a registered document, is undervalued one. And that deed has
all of it relates to the same property which is subject matter of the civil suit.
Yes, my lord. There is a civil suit pending between the parties.
Correct.
No.
Let them work out their remedies before
No,
the
my
civil
lord,
court.
the error is apparent on the
Impugned order.
error is apparent on the face of the order. Now, my
If it is error apparent, you withdraw the appeal and go and review petition.
My lord?
If there is any error apparent, you withdraw the appeals and go and review petition.
Only submission is that the land which has been mutated belongs to somebody else.
So if it is an error apparent in the face, then you file a review petition, sir.
And that can be raised before the civil court because it is all fiscal
Liberty may be given.
All right. Counsel for the appellant seeks leave to withdraw these appeals with liberty to file a review petition before the single judge in accordance with law. Disposed of is withdrawn with liberty is paid for. All right.
Item 69 to item 73.
Miller, 69.
Yes.
I think
16, from 69 to 73.
73.
Supplementary item 74.
May I play lordship? In this matter, lordship, petitioner files a representation before the Tahsildar.
Eviction of private opposite parties.
Yes, I meant private opposite party, lordship.
All right. The petitioner's representation dated?
Dated, your lordship.
28/7/2022
Yes.
shall be examined by the collector.
Tahsildar collect. Yes.
Tahsildar Belgunta.
Yes,
bracket opposite party number 5, and after issuing notice to the petitioners as well as opposite parties 6 to 8, hearing a reasoned order shall be passed not later than 1st February 2022 and may be made available to the parties within a week thereafter. The court clarifies it has not expressed any view on merits. Right.
Item 75.
Lordship, opposite part number 1 has find out, I may be permitted to address the lordship on virtual lordship. Opposite part number 1 has fixation of fixed one place for cremation ground lordship. And he has assured also to convert that land as a cremation ground. Filed annexure 2 at running page 10 lordship. The Oriya is at annexure at running page 9. The English translation copy is at annexure 10 lordship. The lordship has a glance to the running page 10. By virtue of the notice, it has been brought to the notice of the general public by meeting dated so and so. It has been decided in the office of the Bhushanpur Phandi for the cremation on disputed land has been finalized, whose plot number 136, area so and so, and in the Mauja Jhansi Patana.
We will ask him to dispose it off. All right. You say the petitioner's representation, bracket annexure 3, shall be examined by the Tahsildar Tangi, bracket of party number 1, and after notice to the petitioners and giving them a hearing, the reasoned order shall be passed thereon not later than 1st February and be made available to the parties within a week thereafter. The court clarifies it is not expressed any view of the matter.
Most obliged.
Item 76.
76. In paragraph 5 of the judgment, while arguing on that of 29 to 2022, I have not said so. Because that has been reflected, I will misunderstood before that. I pray paragraph 5 may be deleted, madam.
What, sir? Remember you were saying that? This was very much there, sir. This was not denied by you. So having heard learned counsel for the applicant, the court is not inclined to grant the relief is prayed for in this application. It's accordingly dismissed. Right.
Supplementary list item 77.
None appears.
Item 77.
Withdrawal, which a memo is taken in record, dismissed as withdrawal. All right.
Item 78.
Yes, my lord. State is the appellant before lordship. Your Lordship may kindly see page 27 of the writ appeal.
What's the delay, sir?
12 days only 10 to 12 days.
Delays condoned.
Page 27. This is the government notification of Health and Family Welfare Department dated 27th February 2050. Your Lordship has had many cases on this subject that we have decided as a policy not to give license to operate the drug medicine shop within the premises of any medical. That is from 2015. Now, this policy is not challenged by anybody, nor by the respond number 1 before the honorable single judge in the writ petition. What has happened, my lords? This respond number 1 was allotted with your Lordship must have remembered that he was occupying a premises within the Capital Hospital campus, and the matter was litigated between the Capital Hospital and the Lordship. In this honorable court has directed that he should be evicted from that place forthwith, and he should be allotted with another area shop room in the utility complex of the medical camp. Now, according to the direction of this honorable court, this division bench of this honorable court, we executed agreement with the respond number 1 for operating the shop in the utility complex shop room number 7 and 8 for 1 year. Because why 1 year? Because there is a policy decision of the Capital Hospital, which was prevailing on the date of execution of the agreement, that we will execute the agreement for 1 year, but subject to renewal from year to year. And this is the policy. Then that policy is also not challenged by anybody. Now, he applied for permission license before the drug controller on the basis of that agreement. Drug controller under Annexure 8 to the writ petition rejected his application on 2 grounds. That is, as per this policy decision of the state government, no permission, no license can be granted to anybody to operate the medicine shop within the medical campus, number 1. Number 2, your agreement is for 1 year. It should be 5 years for the purpose of entertaining an application for license. This is secondary ground, second ground. The first ground is that as per the government notification, we cannot grant the license. The party again come to the honorable court before the honorable single bench, challenging that order of the drug controller and asking the Capital Hospital to execute the agreement for 5 years to enable him, to facilitate him for applying the permission before the license before the drug controller. The honorable single judge, after hearing the parties in the impugned order, made 2 directions. First direction is that you extend the time period from 1 year to 5 years, which is against the policy of the Capital Hospital. And again, another direction was issued to the drug controller, who is also one of the appellant before your Lordship in this appeal, that you grant license to the party for operating the day and night medicine shops within the capital. That order is set. These 2 are, so far as the second one is concerned, regarding issuance of license, that is not at all permissible in view of this government decision, a government policy decision. Now, policy decision is not challenged by the petitioner. That is still in operation. So my response submission is that we
appearing on caveat or something? No.
Pardon me?
No, is anyone appearing on caveat? All right. You say notice returnable. 21st December. There shall be a stay of the impugned order till then. All right. Delay controlled. This correctively tagged with contempt, that's something else.
There is a contempt single with that contempt application. If your Lordship is allowing this stay, then we will approach the single bench, honorable single bench, and in the contempt petition, we will make an application to that.
There you can make it.
Yes. That stay order may be granted.
You've already granted.
Oh, obliged.
Item 79.
No, I'm appealing for the state here. Item 79. It is similarly issued to item 78, Your Lordship.
Same matter.
But the facts are a little different. There were no previous round litigation as in item number 79.
All right. You just say notice state election. Same date. All right.
Item number 80.
Extension of time.
The extension of surrender.
When were you granted time to surrender, sir?
15 days, 15 days time.
No. When is it expiring?
Expire 15th October.
Okay. Time to surrender is extended till 31st October. All right. The application is disposed.
Item number 81.
This is coming online or online?
May I please? Let's say I am for CRL number 6 of 2022, 2020, 9 of 2020, and 16 of 2020. Can you take up after 2 weeks after?
Paper books are all ready, sir. No, you want to supply criminal antecedents, 65,
Yes, my
16.
lord. My lord, we have called for the criminal antecedents. Some accused persons, we have the criminal antecedents, my lord.
So 3 of the appellants are already on bail.
Yes, my lord. And if I can submit honestly, my lord, they had antecedents. Final form, But I'm yet to receive the antecedent report, my lord. If you
All
lodge,
right.
we grant a short date, my lord. I'll
The
just get it.
additional government advocate appearing states that she needs some more time to supply information of the criminal antecedents of the appellants and criminal appeal numbers 65, 16, and 643 of 2020. Aircraft counsel for the appellants in the remaining appeals seeks adjournment. List on 14th December.
For admission item 82.
82, my lord, Mr. S.K. Padi, senior advocate, has been admitted to Apollo, Delhi. He was discharged yesterday. I'm only praying for some time. I've informed
All right.
Mr.
S.K. Padil, senior counsel appearing for the appellants. The petitioners is stated to be some difficulty today. List on 21st December.
Okay.
Oh, actually, we just 11 January. 11 January. We'll continue after lunch. We'll take this up after. Mr. Panigrahi.
Supplementary list item 1.
May I please your lordship, my lord?
Yes.
My lord, my response submission with due diligence, my lord. In earlier occasion, your lordship was pleased to dismiss my limitation petition, my lord, by passing error, my lord. That is, please make a glance, my lord. By passing error on, my lord, 25th October 2021, my lord. Again, I knock at the door of your lordship, my lord, filing another petition, my lord, having changing circumstances, having changing grounds on the point of that, my lord. So far, the interlocutory order is concerned, that is not mine. Interlocutory order cannot be treated as a adjudicator, my lord. And my response submission in earlier occasion, as the humble petitioner of the humble applicant, the writ appeal did not file the certified copy of the impugned order, my lord, bearing WPC 24,473/12, my lord. Your lordship was pleased to dismiss my application. I have also filed certified copy of that impugned order by WPC 24,473/2012, my lord. Only my response submission, as the single bench petitioners, my lord, we did not make party to the writ appeal appellants, my lord, and obtained error in 2 juniors towards regulation service, my lord. Ultimately, the petition's right have been hampered. Till today, they have not regularized. And so far, this case is concerned, my response submission. Admittedly, the single bench error came into light, my lord, on my lord, that is the respective submission, that is on 22 January 2019, my lord. However, that came to knowledge of the petitioner, my lord, on 21 March 2022, my lord. So after, that is March.
No, Mr. Panigrahi, Mr. Panigrahi, what is your prayer in the interim application? What is your prayer in the interlocutory application?
My lord, my interlocutory application to condone the delay, my lord, that is.
How can you say the writ appeal itself is dismissed? The writ appeal itself has been dismissed now.
No, writ appeal, sir, has been dismissed on the ground of delay.
Correct.
And
So
thereafter, he filed another application to condone.
How can it's not even maintainable?
Only my submission, my lord. I pray a matter may be withdrawn and liberty may be given to challenge the single order for setting it aside by filing fresh writ, my lord.
No. Where's the question, sir? Where's the question? You say the writ appeal has already been dismissed on the ground of delay. There's no question of entertaining another application after the dismissal of the writ appeal for again condoning the delay. The application being misconceived is hereby dismissed. All right. Sir.
My lords, I had filed an affidavit in this matter on 5/4/2022. My lord, there, according to the expansion of the SCB Medical College campus, the walls were supposed to be broken and the vending zone was to be shifted. Now, my instructions, my lord, are,
This is not the case.
I'll just complete. My lord, now my instructions are, I'll just finish. My instructions are, my lord, that the design has changed. The road that was connecting the medical road to the embankment, that is the outer ring road, that road has been completely blocked off. There is no entrance from that side. So the question of a traffic congestion now will not arise. My lords will allow me to file an affidavit to the effect with all details, but for better appreciation.
That will do. What about the other main issue?
No, my lord. Last order in this case, that photographs should be given to this honorable court to know the recent photographs. Unauthorized people are continuing with the help of this organization. I'm sorry to say.
There is a question of any unauthorized action.
There is clear order.
No. There is no order. I'll just
let it come after main case. I'm not prepared.
That's a much earlier order of this Honorable Court, my lords. And subsequent to this order, that vengeance zone was established. Now the situation has changed. So once I file the affidavit, if my lords permit me, then the situation will be clearer. The allegation is that there is permanent construction on the drain. That is wrong. That is false. These are only temporary fabricated structures which are on the drain pursuant to that order that my lords are now looking at. And those are removable. So the moment there is any blockage, the drains have to be cleaned, they can be cleaned without any problem. Looking at the order that is now before my lords, this entire arrangement has been made. So now, because the connecting road is now blocked off completely, that road is not existing anymore, the situation has changed. So if I file an affidavit, my lords will have better appreciation of the situation.
All right.
Then what is the problem, my lord? The photographs.
So I'll supply photographs also along with the affidavit.
Okay. Mr. Nayak, learned counsel appearing for the Cuttack Municipal Corporation, states that the road connecting the SCV Medical College to the ring road.
CDMA.
I'm for CDA Cuttack Development.
CMC. He has just dictated that CMC. You are appearing for CMC.
My lord.
That's what I dictated just now. Says that the road connecting the SCV Medical College to the ring road has been completely blocked off. He states that he will file an affidavit together with photographs, placing on record the correct present position by the next date. What about the main issue, sir? Mr. Samantray.
I filed it, Milord. I've already filed it. I've given a copy to my learned friend, Milord. The entire report, Milord, crack team report, losses wanted, Milord. I've already filed it. Detailed report.
I am sorry to say that this is a serious health matter regarding the right to treatment of needy and poor. I don't know why the state is evasive on this subject. Your Lordship directed the DLS to give the report. They have given the report. They have given the counter, and that is also evasive. Let me everywhere. In Cuttack district, the team found a gate was locked.
Where are you reading, sir? Where are you reading?
39, sorry. Page 39.
Yes.
Last PSC in Mangarajpur. The committee report was non-present. Gate was locked. But that is not mentioned here. In the video, that gate is locked. There are 2 shifts for treatment. They answer that in an evasive way. And that is the tip of the iceberg.
No. Where are you reading, sir? Page 39?
39 of their report.
39 is Bargad.
31, sorry, sir.
Which page are you reading, sir?
I am reading 39. Above it is written 39. Below it is written 31. So below if it is written 31. Page number.
1 minute. I don't know. There is no below page number at all. 31.
That is the beauty.
Milord, I think my learned friend is referring to that report submitted by the DLC committee earlier.
Oh, not your report.
Not our report.
No. That report I have not taken yet. That is not given me.
Which report?
The
government's report you do not have.
This is their report given me today. Even in that period, I could gather that they are evasive.
No, you're referring to their report or some other report?
Their report where they have contradicted the finding of the DLS.
No, the report submitted by them is flag O, sir. Please refer, sir. Please refer to the last report that they have submitted, the government.
They gave it today. But still I could find that their report is evasive as usual. And therefore their report 32 page. I'm reading.
You're first saying 31, then you're saying 39, now you're saying 32. 32, some photographs.
31. Below 31 is 39. There are two numbers here.
No, I think you're referring to the wrong report, sir.
If they have given me that report, what I can do?
This is, my lord, annexed to the additional counter affidavit filed by opposite party numbers 1 and 2 is referring to annexure ZM by 1. Counter affidavit.
Give me your.
No, there is ZO by J.
My lord. ZM by 1 is what is annexed to the counter affidavit filed by the state. Opposite party numbers 1 and 2.
It is a deliberate mismatch.
Page 31.
Patna district, Mangalpur, Mangarajpur, PSC. Just tell them.
Running page 39.
39, is it?
My lord.
1 minute, 1 minute,
31.
1 minute, 1 minute.
Last part, my lord. PSC, Mangarajpur.
Correct. PHC Mangarajpur.
Our finding, DLS finding, non-present. The video says gate was locked. They answered it like this. There are two shifts of treatment of patient. One is ete to ete. During they have not answered why gate was locked and non-present. That is one of the rare. I got it just 2 hours before. So there is entirely the report.
No, there are two reports, sir. One is the ZM 1 by 1. There's another additional counter affidavit filed by opposite parties 1 and 2. You not served that?
Yes, I don't know.
On 30th September. On 30th September.
My point is that DLS report has been contradicted by them. That is my point.
No, this is the earlier report. Now, subsequent, I am giving to another 2 copies.
Yes. No. He got angry with me. Honestly. My lord said, to give me a wrong report. And
Because in the earlier report I gave, subsequent both I gave. Why should I give a wrong report? 2 copies I have given.
I will request my lord to give it today, tomorrow, and in the chamber. I don't want to embrace the government. I am not their enemy.
No, I don't know, because I am also find myself to be an amicus curiae in this case, not as a government counsel. Why my friend is getting annoyed, I don't know. It's for the benefit of us only.
No.
I find myself to be an amicus curiae, not a defending the case.
There was a reference. You just took time, and you didn't do anything for a month. You are not doing anything for verse 18. मत गोटे रिपोर्ट नहीं दस्तखत करेंगे आ गोटे रिपोर्ट मत दउछ व्हाट इज दिस नो आई एम नॉट देयर even the page report is not available with me, my lord. Registry was directed to give me the copy. That is not there. I have the pen drive. I have collected things on the pen drive. Let me submit, my lord.
Have you gone and visited any of these facilities, sir?
I have got information, visited Jagatsinghpur and 2 other districts.
When did you visit them?
A month back, 1 month back, before that date.
You have photographs of your visit?
That I will collect if you are I am not here to DLS committee. I accept their report.
No.
And I pray also, my lord.
Even nearby, sir, Cuttack, you can go to the Cuttack facilities and see for yourself. It will only be 1 hour drive. Whether it's Mangarajpur, Tangi.
I have not taken. You will direct. My brother Samandra and myself can go to city hospital tomorrow. There is nothing, no improvement. I'm sorry to say. And I have, from that pen drive, I have collected information. Let them counter it. For a hydrocele operation, 3,000 rupees demanded.
No,
by
we come
agent
to all.
in
No, no.
ongoing.
Basic, first of all, staffing pattern, availability of beds.
And on my this petition, my lord, dalals were detected. They were not detected previously.
What is
dalals? They are taking away poor and patients. The health business has become very business.
No, but have you been to any of these facilities earlier? Have you been?
Yes.
Now have you been?
Yes.
Everything
There
is
is
saying
no.
yes.
Hey, city hospital I have visited yesterday.
No, but any of these outlying, sir, in Cuttack, there are so many outlying stations, Baranga, Magarajpur, Tangi. Have you been to those places, THC, CHC and all?
When DLS,
unless you move around, sir, unless you move around, how will you know? Is there an improvement? No improvement?
Do they claim that they have obliged your lordship by attending DLS report? Let them come.
Sir, they have submitted a report. They have submitted 300-page report.
To misdirect your lordship. I'm sorry.
You can't just dismiss off the whole thing like this, sir. Then see, if you're going to be adversarial, there'll be no progress. If anything they submit, you simply reject. You say no, nothing has happened. Everything is false. Then how will we make progress?
Your lord saw it now. In the morning they gave me a report. Just I could find out.
If you want time, we'll give you time, sir.
Yes, let me try.
If you want time to examine it, please, you ask her for it, we'll give you time. But without reading the report, how can you simply say?
They want that your lordship should not be here, so that they will again cheat some other body. I'm sorry,
Mr. Mohanty, please. We have made sufficient progress in this matter. You're diverting from the main issue.
No, my lord.
And we are listing it early.
Not against the government.
Sir, so much progress has been made in this matter. Was it there earlier? You filed this petition which year? 2018.
Yes.
Did you get these 400-page reports earlier?
No.
So don't simply dismiss of everything.
I'm not dismissing. I just pray one thing.
We are not here to satisfy you, Mr. Mohanty.
No.
This is a PIL. Yes. Please approach it in a non-adversarial manner.
I'm not approaching. The deal, I just pray, my lord, you have given a fact-finding team for the district. I pray humbly to give a fact-finding team for the medical colleges, and they are the main.
Sir, you already have victims. 600 pages of reports. Have you analyzed it? Are you able to present to the court the analysis of your analysis of these reports?
I have no report, my.
What are you saying?
This
is too much, Mr. Mohanty.
No,
I'm sorry to say.
Then let it come tomorrow. I will go through it in the night.
Sir, so much of data you've got collected, DSA, LSA is collected, they have collected. You're not studying. Mr. Mohanty, I'm sorry to say, you're not studying any of these reports. You're not presenting before us as an analysis of these reports.
They have not defined that report. That is my point.
What?
They are defining the DLS report.
You have not, sir, have you made an analysis? You're just making sweeping statements. Have you actually analyzed these reports?
I had no time, my lord, to that.
Sir, then why is this PIL? Who is? If you have no time, why are you pursuing this PIL?
Tomorrow, let it come tomorrow, my lord.
Overnight, you will understand 600 pages overnight.
Yes, I am very much acquainted with the health.
I'm sorry, we are more practical in these matters. We are far more serious about these matters. I'm sorry to say this. I don't think he's serious about this. He's not even studied the DLSA reports. Have you studied the DLSA reports?
Yes, my lord.
Where is your analysis of that?
I have not.
Mr. Mohanty, let's be very clear. You're a petitioner in person. You have to assist the court.
No, my lord. Please have faith and I pray for your that report is not given to me. I have collected it from pen drive only. That report is still with the registry.
No, it is only in a pen drive,
Yes,
sir.
pen drive it was given to
Even the registry is only in the pen drive.
No, the paper report also there.
No, nobody got paper report.
So we got it downloaded from the pen drive. You can also get it downloaded from.
Yeah, he has it. He has it on a pen drive.
I have given. I have some report there. No? Then I am reading that. In Bolangiri, lift man he prescribes medicine.
Sir, not. I don't know. I don't know how
That is the
to
report.
make him understand also.
That is the report.
Mr. Mohanty, with the greatest respect.
You order, my lord, what I should do.
Sir, you have to study the reports. You're like an amicus to the court, correct?
I am prepared for that. I tell him, my lord, in one day I can do this. If you want the next week it will come, let it come.
You see, an additional counter affidavit has been filed by opposite parties 1 and 2 enclosing further report of the visits to the various health facilities by the crack teams. This is a 380 page report. Stop. It may be noted that earlier another affidavit had been filed on 24 July 2022 enclosing an equally voluminous report running to 166 pages. Full stop. Copies of both reports have been handed over to the petitioner who appears in person. He seeks time to analyze the said reports and present a note before the court on the next date. Full stop. He is requested to make a comparative analysis of the various reports of the DLSAs with the above reports and inform the court what specific directions are required for improving the what specific directions are required. Full stop. Then this paragraph.
My lord, with your lordship's kind permission, there is a connected case WPC 15134 of 2016. The party says it is not required to be proceeded further. May I pray it may be permitted to be withdrawn?
All right. 15134 of 2016 comes with the petition
that item
to withdraw this petition. Dismissed as withdrawn. What about this 16602 is what? That's the one that I was submitting earlier.
The first part, I think that is
will be in 16602.
That is to the first item.
Right. All right. January. Opening day is 3rd January.
Pardon me, my lord. I pray for a similar team for medical hospitals.
Let's first do this. Do all that. Let's first get into PHCs, CHCs, DHH. This is important, very important, sir. All right. 3rd January.
Item number 84.
May I please, my lords? I'm appearing through virtual mode, my lord.
Yes, please.
Obliged. When the petitioner number 1 is a senior citizen, aged about 78 years, my lord. The wife of the petitioner number 1 is also a senior citizen, my lords. He passed away last week. Due to old age, she passed away, my lords. So the petitioner number 1, my lords may have a little sympathy towards the senior citizen and grant him a short adjournment to file the affidavits and the photographs. It's a PIL matter.
Mr. Consul, the petitioner who needs some more time
to comply with the earlier order. Just on 4th January.
Highly obliged, my lord. Highly
Item
grateful.
85. 85.
On the other day, my lordship directed the state to take instruction and to file their counter. Counter I have received. Try pray some more time to file my rejoinder to
All
the
right.
same.
Rejoinder to be filed with the next date, 5th January.
Item number 86.
Lordships.
So today I'm filing the rejoinders. They have filed the government has filed counter. This is a matter relating to construction of Anganwadi center over an objectionable area, which is as per the guidelines issued by the government, is completely it's not permissible to construct such level building over that plot. But here the petitioner.
Let me go through the rejoinder. I've been served with the rejoinder.
I have just given the reply. I have given that the in para 2 of my rejoinder complete. I have specifically mentioned that. I have replied the entire thing. In para 2, I have mentioned that. Para 2 my rejoinder copy. I have given the photocopies also. What they have told, I have given that answer. May I read the para 2 of my rejoinder?
All very confusing what you're saying, sir. Totally confusing what you're saying. Now you're saying there are no encroachers.
Let's encroach there. No, yes, there is no. Their government is saying encroachers there, but actually there is no encroachers. They have these private lands, and the petitioner that is the.
Whom are you? Why have you filed this PIL? This is a PIL.
Yes, PIL.
No. There seems to be some private interest litigation.
This is the individual.
Not a PIL, sir. Sorry.
Listen, blood. Individually, I have filed the individual case, blood. My lord has directed to file a PIL. So that is why it has come PIL. Otherwise, I had to file the individual, blood. Individual, the petitioner has filed the writ
civil
application.
suit, you pursue all your remedies in the civil suit. Yes. There seems to be some injunction order also by the trial court.
Yes, that is in my.
You're firing on two ends. That's the whole problem.
No,
you also in the civil court. You're also filing PIL. Like
no, I am not. I am not patting, blood. Blood, Lordship, kindly hear me, Lord. But this is not, blood, what Lordship say, that is supporting me. But I am against that construction because there is a dispute pending over that plot. There is no way to go to the school. Government saying that place has been identified by the government. That is, this government saying that plot is conducive for all the children to go there. But actually, there is no way because the dispute is pending. So, as per the guidelines, when the dispute undisputed place are there, then that can be constructed. So, I am saying that disputed place is there. So, if Lordship will go, that report is in my favor, at least in my favor. But I say that should not be constructed there. Other places there. Let it go. Then let it be constructed in other places. But government is saying that way is there, but there is no way. So how the school can follow around?
In fact, my lords, pursuant to my lord's direction, in February, we have filed a sketch map where we have shown that there is a 20 feet road. We have given photographs. The construction is over. So, and my lords, there is no, my lords,
there is no way. There is no way to go to the school. So how it can that dispute is pending. Dispute is pending. What they are saying. They are breaking my boundary wall, and they are saying that in that way the student go. How can it be that private land you will others to go there? So that is the injunction petition is there. That injunction is in my favor. So government cannot go the lab.
You pursue that, sir. If the injunction is your favor, you pursue that.
No, I said
not entertaining like this several petitions on the same issue.
No, that I am saying why I have filed this petition, Milord, because government is saying that schools should be established there. I say, but all the villagers are saying that school should not be constructed there because against the guidelines.
Is it school or Anganwadi center?
Anganwadi center. That is that Anganwadi center.
So everything is same for you. School,
Anganwadi building. That will be Anganwadi center of the building, Lord. They have constructed that building over that plot, which is adjacent to a tank, adjacent to a funnel ground, and also there is a private land around the school. There is no way. So how can they construct the
after perusing the rejoinder and after hearing counsel for the petitioner, the court is not satisfied that this is a bona fide EPIL. So it appears that there is already a civil suit concerning the land in question in which some interim orders have been passed by the civil court. Full stop. Clearly, the petitioner is trying to have litigation continuing in several courts.
No, I am not. Sorry, Lord. I was not party there, Lord. The civil suit, I was not party, Lord.
Okay. The court is not proposing to therefore entertain the present petition since the subject matter of the suit and the present petition seems to be identical. Full stop. Paragraph as regards the main grievance, the stand of the council of the state is that there is a clear 20 feet road that provides an approach to the Anganwadi center.
Well, actually,
the construction of which has already been completed.
But there is no way, Lord. But there is no way. But there is no way at all. Yeah. But they are saying that 20 feet, that is where is it? Let them produce the documents. Where the 20 feet
the court is not willing, therefore, to entertain this petition any longer. It is accordingly disposed.
But there is no way, Lord. Let them produce the document. They say that the way is there. 20 feet is not there.
All right.
It will be completely against the guideline, Lord.
Right.
That should be constructed over and undisputed land. But this is disputed land. How can it be constructed, Lord?
All right.
Item number 87.
87, I filed a counter. I have served a copy to my learned friend, my lord.
Served with the copy. Counter affidavit has been filed on behalf of opposite party number 3, copy which has been handed over to the counsel of the petitioners. File a rejoinder then. Rejoinder to be filed for the next week. 10th January.
Pardon, Your Worship. 10th January.
10th January. Obliged.
Supplementary list passed over matter item number 37.
May I please, Your Lordship? I have challenged the order passed by the Honorable Single Judge. Your Lordship may kindly come to page 18. 18. The Honorable Single Judge has held that the information sought for by the petitioner is irrelevant, vague, and vexatious. My Lord, this order is passed basing on the order passed by the Lord CIC, Central Information Commission, my Lord. The Central Information Commission, my Lord, has rejected my appeal on the ground that no larger public interest is involved. It is at page 27, my Lord. But nowhere the Act provides that the information will be provided where there is only public interest, my Lord. Nowhere it is provided in the Act, my Lord. The Act said that every information will be provided, my Lord. And the denial is an exception, my Lord.
What have you asked for?
My Lord, I have asked for information how many prepaid mobile connections were working in Odisha. And some other informations, my Lord.
For what? What is this? What kind of information? Why do you need it?
Miller, large-scale corruption has been made, my Lord.
In what?
In providing connections, my Lord. In Hello Tune and also in prepaid connections, my Lord.
What is that large-scale corruption means what?
Miller, they have provided connections to ineligible persons and they have not provided to eligible persons, my Lord.
That's some vague, sweeping allegation you're making, sir.
Miller, the information they will provide, my lords. No. It is their duty, my lord. The law says, my lord. They have relied upon certain documents which is not applicable in this case, my lord. Your lordship may kindly say section 4.
Huge and voluminous, sir. This page 26, come to it. It's really huge and voluminous, this information that you're asking.
They are saying they're voluminous, my lord.
Yeah.
They could have provided by means of floppy, my lord.
No.
They cannot deny, my lord. Yes, my lord. There is a provision, my lord. They can provide in other mode, my lord. If it is not possible through that paper mode, my lord.
What does the single judge say? Let us read the single judge judgment.
Only relied upon the decision of the CIC, my lord, and has held that it is vexatious, my lord. Last page 18, paragraph 12. Only your lordship may kindly see section 4 of the Act, my lord. That is a very important provision of the Act, my lord. It is the duty of every authority to disclose everything, my lord. Except section 8, my lord. Where disclosure is forbidden, my lord. But as there is some corruptions involved, they are not disclosing, my lord. Lordship, I'll see the decision of the CIC at Annexure 5. Starts from page 25 and the last page 27, my lord.
Sir, all this is now dated. You wanted information up to December 2013. 9 years down the line, sir. Now, if you get information of 2013, what do you propose to do?
Law should be decided, my lord.
What do you propose to do now with that 2013 information?
My lord.
You can't do anything.
They are duty bound
all
to
this,
provide.
if it is not done in good time, all this is not done in good time, it loses all meaning, sir. What is the point in getting some 10-year-old data?
My lord, as some corruption involved.
After 10 years. So you start investigating corruption that took place in 2012, 2011, 2010 now. In
No,
2022.
not now, my lord. Immediately I applied, my lord. They did not provide, my lord.
Today, if they provide you, you
Miller.
will want them to investigate corruption of 2010.
Miller.
In 2022, they'll sit and investigate corruption of 2010.
Lord, they should not be scot-free, my lord. That is not
scot-free, sir.
That is not my fault,
about,
my lord.
It's about how you pursue matters. You filed this writ appeal in 2016.
Miller.
Till date, you have, at least I have not heard you mention this appeal before me for the last 21 months.
I have not mentioned.
So you're not serious. So why blame anybody else? You are yourself not serious, sir.
Lord, the question is, my lord.
See, there is a limit to how much the court should interfere and for what purpose.
My lord, if it is disclosed, my lord, something will be honored.
What will happen?
My lord, he may approach the localypt, my lord.
It's all a waste of time, sir. Complete waste of time. The challenge in the present petition is to order dated 19th August 2016, passed by the learned single judge, dismissing writ petition civil 1719/15 filed by the appellant. In the said writ petition, the appellant had challenged an order dated 13/2/2015 of the Central Information Commission holding that the information sought by the appellant was not in larger public interest and therefore cannot be provided. Full stop. Inter alia, the information sought by the appellant, who happens to be an employee of the Bharat Sanchar Nigam Limited, regarding the total number of prepaid mobile connections in Odisha Circle as of 31st December 2013. The number of prepaid connections particulars of activation of single quotes hello tune on prepaid mobiles in October 2013. The stay particulars of all the staff working in GM bracket CMTS units. Full stop. The CIC noted that providing the above information would warrant a directive to the BSNL to collect and compile information at the cost of diverting their own resources from day-to-day work. Full stop. The stand of BSNL has been that the information sought by the appellant is huge and voluminous, contained in several files, and without disproportionately diverting the resources of the public authority, it is simply not possible to provide the information. Paragraph. The learned single judge has found merit in the above contention and has concurred in the view that the information sought is vague and vexatious and unrelated to transparency and accountability in the functioning of public authority. Paragraph. The court further notes that the information sought was for a period up to 31st December 2013. And despite filing the present appeal in 2016, no attempt has been made by the appellant to have the appeal listed early. Full stop. For all of the aforementioned reasons, full stop, the only inference that the court can draw is that the appellant has not been diligent in pursuing the matter. Full stop. For all of the aforementioned reasons, the court finds no ground to interfere with the impugn order of the learned single judge. The appeal is dismissed.
Supplementary list for hearing, item number 88.
May I pray, my lord? May I pray, my lord? I'm on a virtual mode.
Yes, please.
May I pray, my lord, in the place of item number 80, my lord? Your lordship may kindly take up item number 3, my lord, in the weekly list. Short matter, this is a very bulky matter, my lord. One of my associates also expired, my lord. So, item number 3 in the weekly list.
1 minute, sir. We'll call out the list and then we go to the weekly list. Yes. You say in 88, say Mr. Nayak. That's a 1996 appeal, sir.
My lord, one of my associate, my lord, one of my associate passed away, my lord, in the only 10 days back, my lord. So
10 days is nothing, Mr. Nayak.
Passed away, my lord.
10 days is enough to for alternative. I mean,
that's right, man. That's right. And yesterday also, my lord, I have not read in the night, my lord. Your lordship kindly say this matter may urgent to 1 week after, and other matters I'm ready now in the other list. That's my matter. I will place the matter with your lordship. Item number 3.
Total 32 appellants in this appeal, my lord.
Some of them died, my lord. No instruction.
The last appeal, last occasion also, submission that criminal appeal 268, the last one, the sole appellant is dead.
And one Makadam Sahu is dead. Appellant number 1,
that is
233.
Yes, one Makadam Sahu, that is in criminal appeal number 233.
Right.
And in director to give me a copy as to who are dead, so that I will submit accordingly. No copy.
The last occasion, I think somebody has said they will take instruction. I have also called for instruction with 32 appellants.
Yes.
We have instruction in 2020 regarding only 3 appellants who have died.
No, some more have died. Some more have died. That is my instruction.
Last occasion, I think my learned senior had taken time to find out how many people are surviving.
Kotke has taken time.
Mr. Katke had taken much time.
Find out who are the dead in the meantime.
It's all right, sir. We'll decide the appeal anyway. There are some who are alive.
Yes, my lord. Next week, my lord, a report will be called for and a copy may be given so that I will submit a note accordingly.
So whether or not this information is there, you better get ready with the appeal, sir, now. You said the request of Mr. Nayak, senior counsel appearing for the appellants. The list on 18th. 18th October.
Also, they are direct in the meantime, they will obtain instruction regarding the...
No, sir, whether or not that information is there, you get ready to argue the appeal and let's get on with it, sir.
At least those who are dead, my lord, so that I will not make any submission.
What difference will it make, sir? 32 appellants, it's not going to be that individually you have separate arguments, nothing like that.
Your lordship.
Right.
Supplementary list item 89.
The 89, I also may adjourn the matter because during vacation I had some serious medical issues and still I have not overcome. So I pray, my lord, let it pay on 26th.
All right. At the request of counsel, the appellant list on 26th. All right.
Obliged.
Item number 90.
My lord, on behalf of Mr. Vasudev Pujari, let me adjourn the matter to some other thing. 90.
Are they in jail or they're on bail? 90. What happened to this matters of conviction jail? There was supposed to be a separate list. We'll call that now after this.
Still in custody, man.
Why keep taking adjournment for persons who are in custody?
Mr. Vasudev Pujari went to Nepal, but he reached today, but he could not reach due to some problem. He telephoning.
For people who in custody, there's no problem at all. They can continue remaining in jail.
That is correct. But
everything is correct, sir. Everything is correct.
Let it come tomorrow, my lord. You reach today or today evening or tomorrow morning.
Very unfortunate, sir. At the request of counsel for the appellant, list on. (27th October).
90 miles, sir. In the criminal appeal 465 and 14, I am appearing with another case. Let the matter come 27.
It is already connected. Special weekly list for hearing item number 1, JCRLA 71 of 2009.
May I please, Your Lordship?
Yes.
On the basis of FIR dated 13/2/2006, which 12, lodged by PW22, Titlagarh PS case 18 of 2006, corresponding to GR case number 47/2006, was instituted against the appellant, and after completion of trial in SC number 27 of 2006, learned trial court convicted the appellant to undergo imprisonment for life and to pay a fine of rupees 2,000 in default for 1 year imprisonment under section 302 IPC, RI for 10 years and to pay a fine of rupees 2,000 in default for 1 year imprisonment under section 376 2F IPC, and RI for 7 years and to pay a fine of rupees 2,000 in default for 1 year imprisonment for the offence under section 201 IPC. Being agreed by that order dated 14/9/2009, the appellant has preferred this appeal before this honorable court now. The prosecution case is that on 13/2/2006 at about 10 a.m., the accused came to the house of the informant, and thereafter accused called the granddaughter, the deceased Sima Vibhar, and Durjan, the grandson of the informant, to his house to eat not. And many other persons are seen while the deceased, the granddaughter, and Durjan, the grandson, went with the appellant. After some time, after 1 hour, the grandson returned. On being asked, he told that his daughter is sitting in the veranda of the informant. The family members of the deceased could not find out her, and on suspicion, they informed the local sarpanch. Thereafter, information was given to police, and on being sought to the house of the appellant, the dead body of the deceased found, which is aged about 6 years old. In order to prove its case, prosecution examined 22 witnesses, and the accused examined himself as DW1. My respectful submission before your lordship is that in the present case, prosecution has failed to prove its case beyond reasonable doubt. There is a discrepancy in the evidence of prosecution witnesses with respect to time when the accused was found going with the deceased and Durjan. PW1, the grandmother of the deceased, in para 3 of his evidence, has stated that the accused to her house at 7 a.m. and told Sima, the deceased, and Durjan to give chana in his house, and took them to his house. PW22, the grandfather of the deceased, who is the informant, in his evidence, para 1 has stated that on the day of occurrence, the accused had come to his house at about 8 a.m. to 9 a.m. and took his granddaughter and grandson with him. PW7, Sarpanch of the Gram Panchayat, in his evidence at para 3 has stated that at about 9:30 to 10 a.m. he found the accused was coming with Sima and Durjan. PW9, in his evidence at para 1, has stated that sometimes after about 10 a.m. he found that the accused was proceeding to his house with Sima and Durjan. PW10, in his evidence at para 1, has stated that at about 10 a.m. he found that Sima and Durjan were going towards the house of Sanmat, the present appellant, but in cross-examination para 2, he has stated that at about 10 to 10:30 a.m. he found that the accused was going ahead and both Seema Durjan were following him. PW 14 in his cross-examination at para 3 has stated that at about 10:30 a.m., the accused left the house of informant and that Seema was going ahead, then Durjan was following, and after him, accused was going. My next respectful submission before your lordship that there is a discrepancy as to who opened the door of the accused after who was recovered. PW 19, the Habildar of Titlagod PS Milord, in his examination in chief para 1 has stated that the wife of accused opened the door after snatching the sikuli, but in his cross-examination para 5, he has stated that I cannot say who exactly snatched the lock and chain. By means of rod, the door was unlocked. PW1, who happened the grandmother of the deceased, she has stated in her examination chief in para 4, the wife of accused snatched the chain of the door, which uprooted and the door was opened. PW7 in his examination chief para 5 has stated that wife of accused dragged the chain of the door for more than 2 to 3 minutes. The chain of the door was uprooted and the door was opened. PW17 ASI of Police Titlagod PS in his cross-examination has stated that as per his instruction, the wife of accused opened the door by snatching the sikuli by means of tangia, which was kept in another room. The wife of accused broke the lock by giving one blow by tangia. PW22, the informant in examination in chief para 2 has stated that police opened the door. PW10 in para 1 of his evidence has stated that on being requested by villagers, this is important, my lord, on being requested by the villagers, wife of Sanmat, the present appellant, opened the sikuli and the door was opened. By that time, the Sarpanch was present. He intimated police over phone. That means before reaching police, the door was opened. Regarding inquest over the dead body, my lord, my respectful submission before your lordship. In column 9 of the inquest report, Exhibit 5, that has not been filled up by the investigating officer, my lord. The same has been filled up by other person. That column 9 relates to opinion of witness as to cause of death. Under column 9, it has been mentioned that the deceased has been killed by the Sarmat, the present appellant of their village, after commission of rape and pressing throat, and below the same, the signature of Krupa Mahananda find place. But the evidence of PW7 is completely silent whether he has filled up column 9 of the inquest report or not. PW16, the IO in his cross-examination para 12 has admitted that column 9 of the inquest report has not been written by him. Regarding the evidence of doctor, PW12, my lord, the doctor who conducted postmortem report, my lord. PW12, the doctor who conducted postmortem, in his cross-examination at para 2, at para 2, 8th line, my lord, I have not marked any finger mark on the neck of the deceased. Further, he has stated that clearly I cannot say if there was rape, but there are the injuries in the private part. I have mentioned in my report that no stain or clues are detected regarding alleged sexual offense. PW12, on further examination or recall by the prosecution, has stated in para 3 that there is chance of rape and commitment of rape cannot be excluded. Further, PW12 in para 4 of his cross-examination has stated that in my report that no stain or clue is found regarding sexual offense. Therefore, the offense under section 376(2)(f) is not made out, Miller. Now, Miller, the PW13, the Dr. Miller, who examined the accused, Miller. PW13 in his examination in chief at para 1 has stated that no bodily injury on his person, no sign and symptom of sexual intercourse over his genital area, public hair not matted, accused is coupled with sexual intercourse, no physical clue on his clothing. PW13 during cross-examination at para 2 has stated that in case a person commits a rape to a minor girl aged about 6 years, then there must be some injuries on the person, on the said person. Regarding Milord, regarding genuineness of the affair, Milord, that registration of the affair is also doubtful, Milord, in view of the fact, Milord, PW21 is the scriber of the affair. In his examination in chief in para 1 has stated that I scribed the affair as per direction of a Board Vivar of village Sirol. He put his LTI after contents being read over and explained to him. Board Vivar is the PW22 informant. But in cross-examination, PW in para 2, PW21 has stated that on the date of occurrence, I had not gone to village Sirol. I cannot say exact date when I scribed the affair. I have not scribed any report at Sirol village. I scribed the report at the police station. PW16 in his examination in chief para 3 has stated that at the spot I received the written report from the father of deceased. Father of the deceased is not the informant, Milord. This is the shared written report marked Exhibit 12. Further, in his cross-examination, he has stated that I received the affair first and then entered into the room. Prior to my arrival, affair was written by one Harichandra Nag, that is PW 21, Milord. Affair Exhibit 12, Milord, page 58 of the paper book, Milord. Exhibit 12. (9 p.m. 13/2/2008). Received the report at spot. It reveals a cognizance case under section 302, 376(2)(f), 201 IPC. Treated it as plain paper affair and took up investigation. Formal affair will be drawn up on my return to PS. ST eligible IIC PS 13/2/2006. That means IIC received the report at 9 p.m. But the scriber of the affair, Milord, has clearly denied that he has written any affair. He had never went to the village on that date. PW22 in its examination in chief para 2 has stated that then I got scribed one report and presented it to police. PW22 saying that he presented the affair to police, but PW16, the IO submitting that I received the written report from the father of the deceased, Milord. But in cross police and I put my LTI, I have narrated the entire occurrence to police, but in cross examination in para 4, PW22 has stated that in the morning, I presented the written report. I cannot say the name of person who scribed the report, but in the house of accused, my report was written. That apart, Milord, In the present case, prosecution failed to prove the motive of the commission of alleged murder. Rather, PW1, the grandmother of the deceased, in her cross-examination has stated that that the present appellant has good relationship with us. He was visiting at times to our house. He used to work with my husband while they were going to beat drums and beat baja in different villages. In the present case, prosecution has failed to examine the wife of the appellant who opened the door, mother and elder brother of the accused. That apart, the adjacent house owner of the appellant, Miller. There is no direct evidence of prosecution witnesses that the accused committed rape and murder of the minor girl, and the present accused was arrested on 22/2006, and since then he is in jail custody, Miller. I have prepared a short note, Miller.
All right. Yes, Ms.
May I please? This is a very clear case, my lord. If you come to the two major parts, my lord. One, the being recovered from the house of the accused.
By locking, breaking open the lock.
Breaking open the lock. And secondly, there's a last sin theory. All the PWs have stated that they have seen the accused taking this. Only the discrepancy of the timing is there, which is very natural because they're all villagers. They don't go by the clock, my lord. It's not that they've seen the clock and they've said they were just citing the approximate time at which so everybody has said morning 8 to 10. Within 8 to 10, in the morning hours, they have seen the accused take the deceased along with her brother. Third is, my lord, the doctor's opinion, my lord. It's very clear. I think my friend was saying that there was no injury on part of the accused. So that doesn't hold good, my lord, because he was examined after 6 days. And moreover, the injury on the girl, my lord, if your lordship will, I'll take your lordship to page 21 of the judgment, my lord. Running page 23, page 21 of the judgment, para 16. Very clearly, if your lordship will ask, permit me, should I read it, ma'am?
Yes, yes.
The medical evidence of PW12 reveals that on 14/2/2006, he conducted PM examination of the dead body of Seema Bahar, being identified by Havildar K. Chandan and Constable Dharwa. On an examination, he found as follows. 1. Rigor mortis was absent in both upper and lower limb and neck. Postmortem lividity was present over the back area of the deceased. Abrasion multiple in number of size. 2 cm into 1.4.7 into 1.2 cm over the right angle of the mouth and cheek. Multiple abrasion of size 2 cm into 1/4 cm into 1/2 cm over the right side of the neck just below the angle of the mandible. Multiple abrasion over the left side of the neck. Labia majora was congested. Labia minor was vulvarized and congested. Hymen ruptured at multiple sides with hemorrhage. Posterior vaginal walls were lacerated towards the anus with hemorrhage. So, my lord, even he goes on to explain, my lord, on internal examination, larynx was congested, pharynx was congested, trachea was congested and avulsed. All other internal organs were congested, uterus and small in size, and the cavity was empty. PW12 opined that all injuries are antemortem in nature. Cause of death was due to asphyxia and shock. Mode of death was throttling and massive injury to the organ. Time since death was within 18 to 36 years, 36 hours from the time of his examination at 10:45 a.m. on 14/2/2006. He proved the PM examination report by Exhibit 7 and also deposed that the age of the deceased was 6 years and that if anybody commits rape and murder, then such type of injuries are possible on part of a person. From the aforesaid evidence of PW12, it is clear that death of Seema was homicidal in nature. PW12 has also given out in his evidence that the victim was a minor and there was chance of rape and commission of rape cannot be excluded. Though during cross-examination at para 2 PW 12 expressed his inability to see clearly if there was rape. At para 4 of his deposition, he stated that rape has been committed before death. Presence of injury on the private part of the deceased, which were antemortem in nature, would definitely go to show that there was rape or attempt to rape on the deceased, and presence of injury on the neck and cause of death due to asphyxia would definitely go to show that the death of the Sima has been caused by throttling after rape on her. The next paragraph is regarding the examination of the accused, where the doctor says that though he medically examined the accused, but that was after 6 days of the commission of the offense, and that is why probably there was no injury on it. So, my lord, this is a very important aspect, my lord, because the injury on the deceased and deceased being found from the house of the accused and if the accused had put a lock on it and he had absconded, he had fled away, and as your lordship knows, it was opened by his wife, and the dead body was recovered. Underwear and some bloodstained articles were also recovered from the place of from the house of the. There, I'll take your lordship to that portion, my lord. The evidence of PW3 reveals seizure of one gunny bag, bloodstained, MO2, jute rope, MO3, one black colored nylon chaddi, MO5, with cement stains, copper chain, number 4, MO4, 2 white towels from the house of the accused on the seizure list, Exhibit 1. So all this seizure, my lord, very relevant to the crime, my lord, has been seized from the house of the accused and it consists of only one room. So the defense had come up with a story that somebody else has committed the offense and has put the dead body in the house of the accused, my lord, which is completely irrelevant in this scenario, my lord. When the dead body is in the house of the accused, the lock has been seized. It has been opened by the wife, and the police has recovered the dead body from the house of the accused, my lord. And most important is the last seen theories by the PWs. I'd like your lordship to. The learned court below has also resorted to section 106 of the Evidence Act, my lord. Since she was found from the house and the accused has not been able to explain how the dead body has come here and how she has suffered death, my lord. So he has also held him liable under 106 of the Evidence Act, my lord. So whether there are enough circumstantial evidence and the medical evidence, corroborative medical evidence to rape, my lord, which definitely puts the liability on the accused, my lords.
Yes, please. Anything else? All right. Orders reserved.
Item number 2, CRLA 106 of 2010.
You see, none is appearing for the appellant. This is a matter where the accused has been in custody for over 14 years. Over 14 years, of which the registry is directed to hand over a copy of the paper book immediately to the Secretary, Orissa High Court Legal Services Committee, (OHCLSC), who will in turn assign a lawyer of not less than 10 years experience to appear for the appellant. The assigned lawyer will also get in touch with the appellant in prison for instructions. Just on 10th November.
Item number 3, CRLA 192 of 2010.
Same order, just give the date as 14th November.
Item number 4, JCRLA 8,
both the matters.
JCRLA 8 of 2010. Item number 4.
Same order, 11th November, 15th November, sorry.
Special weekly list item number 5, JCRLA 21 of 2010.
Same order, 16th November.
Item number 6, JCRLA 29 of
Sad that name of the lawyer assigned be shown in the cost list.
Lordship, item number 3. Lordship, item number 3, Mr. D. Naik was for criminal appeal number 244 of 2.
No. We are on the special list, sir.
Special list. Item number 6, JCRLA 29 of 2010.
Same order. We give a date of 16th November. 17th.
Item number 7.
No, one minute. Ashish Chandra Rath has been engaged by the OHC LSE. So 6 and 7, they're all OHC LSE lawyers. 6 and 7, why don't you call and ask them to remain present? Don't pass the same order for 6 and 7. Just pass it over.
Number 8.
And none appears. Now give the date as 14th for 8.
Item number 9.
Same order, 15th.
Item number 10.
Oh no, 9 and 10 again. Yeah.
Engagement.
9 and 10 they've been engaged. 11 also they engaged.
10
is again there.
15.
No. I'm saying 10 already engaged.
Sorry.
It's just passing over.
9, 10.
You ask the secretary, why is no lawyer appearing?
Twelve,
same order. Give a date of 17th.
Item number 12.
12 you're there.
When item number 12, the appellant has been convicted to undergo rigorous imprisonment for life and to pay a fine of ₹2,000 for commission of offence under section 302 of IPC, my lord. The petitioner faced trial having been charged with offences under section 498A, 304B of IPC, read with section 4 of the DP Act. And at the end of the trial, 498A and 304B and section 4 of the DP Act could not be proved, and the accused was only convicted for offences under section 302 of IPC. And the allegation is that, as per the affair was lodged by the father of the deceased. The allegation was that the deceased was being tortured by the appellant, who is the husband of the deceased, and the in-laws. In-laws included brother-in-law, mother-in-law, brother-in-law, and the sister-in-law. And they were torturing the deceased. And in connection with that, on the alleged day of occurrence, the deceased died under circumstantial. Deceased died under circumstantial occurrence. My lord, and the informant believed that the present appellant has killed the deceased. My lord, the present case is a case that is based completely on circumstantial evidence. There are no direct eyewitnesses to the occurrence. The case of the prosecution, the prosecution has mainly relied on two things. The first is the medical evidence of the doctor who conducted the postmortem. And the second is the fact that section 106, they have taken support of 106 of the Evidence Act, as because the present appellant was staying with the deceased. So there was, I was saying that it was in the special knowledge of the appellant to prove that he has not killed the deceased. Well, the evidence of PW4, the doctor who conducted postmortem report on the deceased, it is at page number 75 of the paper book, my lord.
Yes.
Page number 75. My lord, the trial court, while considering the evidence of the present of the PW4, has observed at page number 22 of the paper book, the observation of the trial court regarding the injury marks and the cause of death of the deceased. Page number 21, paragraph number 9. May I read? At paragraph 9, the trial court wrote that no doubt admittedly asphyxia relates to failure of function of respiratory system. Moreover, asphyxia can be caused not only by throttling but also by hanging, suffocation and drowning. The death due to asphyxia by throttling means putting extra pressure on the throat, that is pressure on the windpipe, on the vagus nerve and great vessel of neck. In her cross-examination, PW4 testified that in case of hanging of a body and death due to asphyxia of a person caused by hanging, there will be a ligature mark on the neck. Though the ligature mark may or may not be conspicuous, depending upon the object used for hanging. In case of soft material used for hanging, the ligature mark will not be prominent. Likewise, in case of removal of the body immediately after commission of suicide by hanging, there will be slight ligature mark. But she has negatived the defense suggestion that in the above circumstance, there will be no ligature mark on the neck. Accordingly, according to her, death by hanging and death by throttling do not show the same signs and symptoms and death on the same body. It is further admitted in case of throttling, mark of fingertips will be there on the neck, but there will be linear crescent marks on the neck produced by fingernails in case of throttling. Having considered the medical evidence on record in totality, it would appear particularly from injury 6 to 8 that in case of death by throttling by means of an iron rod-like material, no ligature mark would appear on the neck. Nevertheless, in that event, death would be the result being caused by asphyxia. My lord, the trial court has reached at this conclusion, basing on the statement of the PW4, the doctor she says in her examination that no ligature mark was found on the neck of the deceased, but when the material is soft, it may be or may not be conspicuous. May or may not be conspicuous, and at the same time. Now, what does the accused say? The appellant say in his 313 CRPC statement. The accused states. The accused states that he was not at house. He had been to take bath. When he came back, he saw the deceased hanging. He got the deceased down and took her to the hospital. At the hospital, the doctor said that she was received as dead. Now, if the hanging is immediate, the appellant stated that when he saw the deceased was not dead. He was hanging herself. So when the hanging is immediate, when the hanging is not for a particular duration of time or for a long duration of time, there may not be a ligature mark. Also, the trial court says that it is possible when in case of throttling by means of a rod, no rod has been seized. No such ligature material has also been seized, to suggest that the death was by throttling. Another that was not taken in consideration, my lord. In the medical evidence, the first point says that the eyes of the dead body were closed, pupils dilated, conjunctive had congested, rigor mortis present all over limbs. Second point says that face congested, white colored line, fine froth present on the left nostril, dried saliva, mark running from left angle of mouth up to left pinna. My lord, I am relying on the 24th edition of the Modi's medical jurisprudence. It says that in case of hanging, in cases of hanging, saliva will run down from the mouth. That is because after reading out the line, my lord, it is 24th medical. In the other signs, these are the signs that are found on the body of a deceased in case of hanging, my lord. The neck is found stretched and elongated, and the head is always inclined to the side opposite to the knot, and the arms of the loop of ligature.
The face is usually pale and placid, but may be swollen and congested if the body has been long suspended. Petechial hemorrhages are occasionally seen on the face under the conjunctiva and neck. The eyes are closed or partly open and the pupils are usually dilated. If the ligature not presses on the cervical sympathetic, the eye on the same side may remain open and its pupil dilated. It indicates antemortem hanging. The tongue is drawn in or caught between the teeth or protruded and bitten. It is usually swollen and blue, especially at the base. Bloody froth is sometimes seen at the mouth and nostrils. Saliva is often found dribbling out of an angle of the mouth down on the chin and chest. This is a sure sign of hanging having taken place during life, as the secretion of saliva being a vital function cannot occur after death. And this is regarding the medical evidence. My next argument is the other accused person, the brother-in-law of the deceased, the brother-in-law of the deceased, and the sister-in-law. They have been acquitted because the offences under section 498A, 304B could not be proved. The instances of cruelty that were alleged, that could not be proved. Now, my lord, in cases of circumstantial evidence, motive is not, it is a settled position of law that motive is not a relevant consideration if the case can be proved otherwise. But in cases of circumstantial evidence, motive gathers importance, my lord. In this case, the very case of the prosecution relies on the fact that the deceased was being tortured in connection with, he was subjected to cruelty. This cruelty amounted to, resulted in the death of the deceased by due to the killing of appellant by the appellant. But my lord, the cruelty, very fact of cruelty, that is the motive for that has been attributed to the appellant for killing the deceased, has not been proved. In fact, it has not been proved. In fact, the other accused persons have been acquitted. Also, the fact of cruelty for the appellant has also not been proved. So there is no motive for the appellant to kill the deceased, my lord. Thereafter, my lord, the trial court has relied on section 106 of the Evidence Act, my lord. And the trial court has stated that only the appellant was the only person that was staying with the deceased at that point of time. The other accused persons who were acquitted, though they are staying in the same compound, my lord, they are in the same premises but different houses. But they had different houses. Now it's the reasoning of trial court that I'm reading out the relevant paragraph. It's the reasoning of trial. Well, it is at page number 27 of the paper book, paragraph number 11. That is the reasoning for holding the accused, for convicting the accused under section 302. Let me now proceed to examine if the prosecution has been able to establish the charge under section 302 by 34 of IPC against the accused persons. On this context, it is an admitted fact that the prosecution has failed to adduce any evidence with regard to the factum of alleged murder of the deceased by the accused persons. At the relevant time and place added to it, the prosecution has also not been able to establish any motive on the part of the accused persons for killing the deceased. Nevertheless, it is well borne out from the evidence on record that at the relevant time, the deceased and her husband Trilochan were living together in one house at Samal colony of village Chakrasila. Though it was alleged by the prosecution that all the accused persons along with the deceased were jointly living in one house, at the relevant time, as per the defense plea, accused Trilochan with his wife were staying separately in another house, whereas the rest accused persons were staying together in one house, but in one place. In this regard, the evidence of IOPW 17 reveals that the relevant time accused Trilochan with his wife were staying in one room, whereas the other accused persons were staying in another room separately. But the rooms were situated in one compact area within one premises on one side of the road. The joint living of all accused persons in one house has not been proved by the prosecution. It emerges from the aforesaid read with the defense plea of accused Trilochan that the circumstances under which the deceased met her death is especially within the knowledge of accused Trilochan. Law does not enjoin a duty on the prosecution to lead evidence of such character, which is almost impossible at any rate, extremely difficult to be laid. The duty of the prosecution is to lead such evidence which it is capable of leading, having regard to the facts and circumstances of the case. In the instant case, the circumstances in which the death of the accused has taken place, it is impossible on the part of the prosecution to lead any direct evidence to prove the homicidal death of the deceased. Law is well settled that failure to prove motive is not fatal to the prosecution case if the offense committed by the accused has been established beyond reasonable doubt. Proof of motive leads additional support to the guilt of the accused and satisfies the judicial mind about the likelihood author of the crime. My lord, the case of the prosecution was that the petitioner was living with his wife. Now the point for consideration is whether on the alleged day of occurrence, just before the alleged occurrence, when the deceased died, whether before that the accused was there in the house, whether the prosecution has laid any independent evidence.
Your own 313, you say you found her hanging?
In 313, I have stated that in 313 I had been to take bath. When I came from the bath, I saw my wife hanging.
So you are in the same house. What more needs to be proved?
I was in the same house, but to prove that I killed.
No. Now you are making the point that there's no evidence to show that you were in the same place before the death.
I was not in the house, my lord.
Where? The bathroom is where?
Bathroom is not in the house, my lord.
Please. All right. This is a new theory you're floating.
So, my lord, a prosecution. I'm stating. The 313 statement of the accused is in Odia, my lord, at page number 68. There he states that the wife of the deceased was not happy with him.
He's supplying motive also.
And when he had been to take bath, his wife committed suicide, my lord.
Right.
My lord.
So obviously in the same house, he's also supplied the motive now.
My lord, I have found some judgments, my lord.
All right.
It's the judgment of reported in AIR 2021 Supreme Court.
Right.
1249, my lord.
Right.
Shivaji Chintapa Patil versus State of Maharashtra. It is a case of, my lord, asphyxia. Case of asphyxia. On the point of section 106 of Evidence Act, it is at paragraph 22. It says that it could thus be seen that it is well settled that section 106 of the Evidence Act does not directly operate against either a husband or wife staying under the same roof and being the last person seen with the deceased. Section 106 of the Evidence Act does not absolve the prosecution of discharging its primary burden of proving the prosecution case beyond reasonable doubt. It is only when the prosecution has laid evidence which he believed will sustain a conviction or which makes out a prima facie case that the question arises of considering facts of which the burden of proof would lie upon the accused. Shall I provide a copy of the judgment?
Yes.
Well, it is at paragraph 22.
Yes. Right. You just now read that.
My lord. And then to the point, my lord, the case of motive that I said that in cases of circumstantial evidence, motive gathers importance. When the very basis on which the case has been made by the prosecution has not been proved. Because here the case was that the petitioner was was treating the deceased with cruelty, and ultimately he killed the deceased. That part has not been proved. Cruelty has not been proved, and on the same grounds, other accused persons have been acquitted, my lord. It is at page number paragraph 26, my lord. Though in a case of direct evidence, motive would not be relevant, in a case of circumstantial evidence, motive plays an important link to complete the chain of circumstances. The motive relied on by the prosecution is the ill treatment by the appellant meted out to the deceased for not arranging the money from her mother. In this respect, the prosecution relies on the evidence of PW3 and the mother of the that observation, my lord. That though in a case of direct evidence, motive could not be relevant, in a case of circumstance, motive plays an important role to complete the chain of circumstances, my lord. In this case, my lord, the whole case is that the petitioner, the appellant treated the person with cruelty, used to treat the deceased with cruelty, appellant along with the other co-accused who were acquitted. That cruelty amounted to the appellant killing the deceased on the fateful day, my lord. The very motive that petitioner was treating the person to cruelty, that slowly gathered up to the point where the appellant killed the deceased. That cruelty part has not been proved, my lord. It has not been proved. Now it has not been put. Now the case of the prosecution is that it is in the special knowledge of the appellant. Section 106 will come into operation, but before that, the prosecution that does not absolve the prosecution of its burden to prove its case beyond reasonable doubt, my lord. Has the prosecution says that I used to stay with the deceased. I used to stay with the deceased in that house. But in that house, that it is within a premise, my lord. It is within a premise. But there is also, if the present accused persons have been acquitted because they have not treated with cruelty, but only because the appellant used to stay with the deceased. But in the said premises, even the acquitted accused persons used to stay in the said premise. So in the said premise, even though they are not staying in the same house, there was also opportunity for them to kill the deceased. Because as for the part of cruelty, they both stand on same footing. The cruelty, the case of treating with cruelty, that has been proved not against the acquitted persons, not against the appellant. Now, it can't be the only circumstance that is against the appellant is that he used to he stayed with the deceased in that house. The accused has provided an explanation that he had been to take bath, my lord. Now, has the prosecution given any independent evidence that the appellant was last seen in that house before the occurrence? Because the conduct of the accused shows that he says that the appellant only took the body of the deceased. He saw the deceased hanging. He pulled up the body of the deceased and took her to the hospital, my lord. Further, the medical evidence, even the medical evidence, the trial court has assumed that that a rod-like material has been used to strangulate the deceased. But no rod-like metal has been seized, my lord. And regarding the observation that no ligature mark has been found, ligature mark is the doctor himself says that it may be conspicuous or may not be conspicuous, my lord, depending on the material, my lord. And also, when the body is immediately dragged down after hanging, there is a possibility that there will be no ligature mark on the body, my lord, on the neck of the deceased. So there remains a doubt, my lord, regarding the case of the prosecution, that whether the appellant was immediately present before the death.
You're repeating yourself, sir. Go on to the next point. All this you repeated twice. What is your next point?
Except that, my lord, these are the 2 points on who is the trial court has.
Yes,
my lord. And the next point is only regarding the circumstantial evidence, my lord. The circumstantial evidence says that is the rule that has been laid in the Sarath Vidya.
That's not a point.
My lord.
Yes.
Well, I just got hold of the paper book right now, my lord. I've not got. But nevertheless, my lord, if you go to the position of the doctor, my lord, it's a clear case of homicide. It's not a case of death by hanging. It's a case of strangulation and throttling and asphyxia, my lord. And your lordship, most importantly, my lord, there are abrasions on the elbows, which goes to show that there has been struggling. She has been laid on the ground and she has been throttled. So how those abrasions, I'll take a lordship to the doctors at page 75 of the
Yes.
deposition, my lord. And at page 76, my lords. Injury body, my lord, I'll take a lordship to.
No. When did they discover the body? After some time, is it? Why are there ant bite marks? Page 76, there are ant bite marks.
Yeah, on left elbow. Yes, I was also seeing that.
Behind left ear, lower lip, upper lip. So what happened? The body was lying there for some time, or?
I'll come to that, my lord. Before that, there was abrasion. And the next point is, my lord, there was abrasion of size such and such on vertebral column in the 10th vertebral area. There was abrasion of size near the left elbow. There was another abrasion of size 1 inch into an inch on the right elbow. Abrasion of size 2 inches into 1.5 inch on axilla before the axillary pit. Abrasion on sternum. There were 2 numbers of dry brown parchment-like depressed areas of size 4 cm into 2.5 cm and 4.3 cm into 1.5 cm directed onwards and outwards found on the left side of the trachea. Abrasion of size at the top of the depressed areas found. Another eel-marked depressed area of size 3 cm into 2 cm on right side of trachea having abrasion of 1 cm on top of the trachea was found. Base of the depressed area were pale but surrounded areas were icomized. All the abrasions are antemortem in nature.
So subject to an assault before the...
It's an assault, my lord. It cannot be a case of suicide. It cannot be a case of suicide. It is a case of... next para, my lord, para 6, the cause of death was due to asphyxia, due to throttling. So it no iron rod or no wooden stick has been recovered from that place, but it clearly goes to show that she had a struggled death, my lord. She has been throttled when she has struggled for her life, for which there was abrasions, and it has resulted in her death. So it's clearly in para 7 she says viscera were kept in saturated solution of common salt. The death was homicidal death. If suicidal hanging is completely different, my lord. Suicidal hanging definitely will not have assault, and there will be ligature mark. In suicidal hanging, there will be definitely ligature mark of prominent nature, with a gap, as your lordship knows, with a gap and a knot and the gap in the. But here it's completely throttling. And my lord, I was just going through very superficial, my lord. I'm not, if your lordship will allow me, I'll again submit further tomorrow. But on the face of it, he has convicted him on presumption, section 114 of the Evidence Act, and 106, because obviously, as your lordship said, they were staying together. And regarding how the body was recovered, my lord, if your lordship will give me some time, I'll then try to find out that.
Place a note, I think that's better.
Yes, I'll do that.
You want anything else to say? No. All right. So orders reserved. Both parties. You want to file a note also, you can.
I'll file it.
Are permitted to file a note of arguments within 2 days?
Yes.
Within 2 days.
Special weekly list item 13.
In same order as the first one, you give a date of 21st November.
Item number 14.
Same.
JCRL 28 of 2011.
Gagan Bihari Singh. Who's Gagan Bihari Singh?
He's not here.
14 in same order. Give a date of 22nd. Both, there are 2 matters. 14. 3, 4, 5. So many people.
My lord, item 14 on behalf of GBC, that paper book has not been received.
So you just collect it right now, sir.
Yes,
stop with all these excuses. The paper book is, you have to go and collect it.
Yes.
You had to go and collect the paper book. Nobody's going to come and deliver it to you, sir.
Yes, my lord. I will collect from the office, my lord.
No, we'll now just now give it to you.
Yes, my lord.
The receipt, you have received it already.
Yes, my lord. Just now, my lord, I'm receiving. Fix up a date, my lord. Another date for hearing.
Already received long ago, not just now. The noting is you already received long ago, sir.
No, on behalf of GB Singh, I have not received, my lord. On behalf of GB Singh.
Say every time somebody files a vakalat, people will not come and deliver paper book to you. If you have taken vakalat from the previous council, you're supposed to collect paper book from the previous council.
My lord, I have not collected.
Sir, what is you have not collected? That becomes an excuse for you to seek adjournment.
I pray before your lordship, kindly give me some time. Just, my lord, by tomorrow, I will collect the paper book from the office. And then, my lord.
Which office, sir? Paper book was handed over to you people long ago.
To the previous council. Yes, my lord, I will collect from him.
Mr. GB Singh already.
Mr. GB Singh has collected it, sir. Who's GB Singh? You're not GB Singh.
No, my lord, I am not GB Singh.
So GB Singh files vakalat, you will now come and take adjournment?
No, because on behalf of GB Singh has instructed me that he has not received the paper book till date.
So he can instruct you whatever. Our record shows that he has received paper book.
GB Singh not received, my lord. He has instructed me, my lord.
Anyway, you first.
Yes, my lord. Yes,
so because you are making these statements, we'll just now show you, sir. It is a limit. We are telling you GB Singh has received. You are blindly saying he has not received.
No, my lord. Your lordship is 100% right. But he has instructed me. GB
You want to believe his instruction or our instructions here?
I will believe on record. Not, my lord, on instruction of my pen.
Then why are you repeating that?
No, my lord.
Because he has told you have to keep on repeating it despite our telling you he has received paper book.
No, my lord. That all the things are on record. I will told him, my lord. I will ask him why you have given me the false statement. And as per your instruction, I have submitted before the court. This is not, my lord, good things, good practice. But because he is my friend, he has instructed me and I have... I will verify, my lord, and I will...
You still have to verify. He wants to be convinced. You better convince him, sir. Not believing you.
No, my lord.
You want proof for everything.
On next another date, my lord, may kindly be fixed.
Tomorrow morning.
Tomorrow? Next week.
Why?
Because some time is required for preparation.
This was there in the list for quite some time.
Next week, my lord, any date.
Anyway, who are the other counsel in these matters? Batch, you're in one matter. In all the others, you're appearing.
Just number 69.
Please speak in the mic, madam. There is a mic that side.
Lordship, JCRL number 69 of 2010.
What about the others? Who's appearing the other matters?
Devi Prasad.
Who's in 519?
Lordship, we are appearing in 519 and 542.
Are you ready at least?
Lordship, to next week any date.
Everybody. Why today is not a good day? Main purpose in criminal appeals is to somehow go and take adjournment. That's the main. First goal is that. And these people are in jail or they've got bail?
In our case, the bail was granted.
So now next thing is only to keep getting adjournments. However much, keep adjournments. I'm glad this is all live streamed. People think judges are not interested in doing work. Judges are not dealing with appeals. At least now they will know how much lawyers are contributing to adjournments. Lawyers are not prepared to argue. They find 1,000 excuses not to argue. Is there any appeal in which no lawyer is appearing in this batch?
No, all are covered.
All are covered. Yeah. Mr. GB Singh, what is your name, sir?
My name is Mr. Deepak Kumar Sahu.
Mr.
On
Deepak
behalf
Kumar
of GB Singh.
Sahu appearing on behalf of Mr. GB Singh, appearing in JCRLA 2011. Mr. Dada appearing in 519 and 542 of 2010. Ms. Panda appearing in JCRLA 69 of 2010. What about 110 of 2014? And Mr. GB Singh, you put in both 110. Want adjournment, saying that they're not ready to argue the matter. List on 23rd November.
Item number 15.
Lord, this matter will be adjourned
23rd November.
of Leicester Lordship.
Item 15.
This stands adjourned to 2nd November.
The connected now.
We call on 2nd November.
Item number 16.
May I please read? In this case, FIR laws under section 498A, 307 and 34 IPC for DP Act. After death of the deceased, the converted the offense 498A, 304 Part B, 34 IPC for DP Act minor. Prosecution in this case, prosecution failed to prove that the 498A and 34 DP Act minor. Alternatively, the conviction 302 only, the appellant only. Admittedly, in this case, there is no eyewitness, my lord. The conviction basing upon only the dying declaration of the deceased, my lord. In this case, husband was allegation, husband was powering kerosene and set fire over the wife, and deceased getting the 90% burn injury and admitted hospital. After that, succumbs injury. In this case, only basing upon the dying declaration method. In this case, the informant is the brother of the deceased, it's the PW 5 method. May I read, Malik? No, informant. In this case, in the law, the accused alleged that the dying declaration of the deceased, informant made informant said to have the deceased made before the PW 5, PW 10, 11, 12, and 13 and 14. And but he has not mentioned in the FIR that the dying declaration before the PW 5, 11, 12, 13, and 15 minutes. Dying declaration, dying declaration is the dying declaration before the additional Tahsildar PW 15 minutes. On 27/12/2007, I was working as additional Tahsildar executive. On that day, as per the direction of the Sub-Divisional Magistrate Puri, I proceeded to the district headquarters hospital Puri to record the dying declaration of the one Mamata Naik, wife of Kalia Naik of Gopandhu Colony, Puri town. I reached the hospital at 2:30 p.m. and went to the female ward where injury Mamata was receiving treatment, being allotted bed number 125, ward number 6 of Puri district headquarters hospital. The IO of in this case, namely Umashankar Singh, of the Kumbharapada PS lead me to the near to the bed of the Mamata. Reaching the bed, I found that the patient Mamata has severe burn injury on her person. She was in to talk that no doctor was available in the side of the bed of the patient. Then other relations of the patients are there. I asked the patient Mamata about to how she received the injury. She told me that on the morning there had occurred a quarrel between her and her husband. In course of the quarrel, her husband poured kerosene over her, set on fire. I record that fact that in a sheet of paper. This was statement which I record the hospital near the bed of the injury patient. The statement is marked as Exhibit 2. This is my signature. The cross-examination. Police officer has not seized the letter which the sub-collector issued to me. In this case, there is no evidence that giving taking dying declaration from a doctor, my lord. Only a police officer requisite the executive magistrate, my lord. Police officer has not seized the letter which the sub-collector issued to me for recording the dying declaration of the injured Mamata Naik. No doctor was available in the ward of the time my arrival of the dying recording of the dying declaration. I have not consulted any doctor regarding the dying declaration of Mamata. I have not recorded the statement of the question answer form. At the time of recording the dying declaration, some persons were present near the bed of the but not taken their signatures on the paper of which I recorded the statement of the injured. I cannot say the patient was very serious when I was recorded her statement, but the patient was having severe injury on her persons. I was examined by the police in the case inside the ward number 6 and the every record the dying declaration. It is not a fact that I have not recorded the dying declaration of the injured, that the injured was not a fit state of health to make a dying declaration, and I was deposing false in the case of the prosecution. In this case, my lord, the appellant was also getting injury, my lord, to save the disease, my lord. The PW 21 is the doctor. On 7/1/2008, I was working as an assistant surgeon, district headquarters hospital, Puri being attached to the surgery. But on that day, Dr. Prafulla Kumar Mahaputra was the surgery specialist in the district headquarters hospital, Puri. One Kartika Naik, son of Braja Naik of the Rai Bahadur Lane, Kumbharapada PS, treated in the hospital. He was an indoor patient. He was admitted as an indoor patient from 17/12/2007 from the date of occurrence. For the treatment, burn injury suffered from by him, he was allotted in bed number 81 in the male surgery ward, headquarters of the hospital Puri. After treatment, he was discharged 7/1/2018. She was getting very serious burn injury to save the disease, my lord. He was in hospital from date of occurrence 7/12/2007 to 7/1/2008, my lord. By the surgery specialist of instruction of the specialist, I intimate the IAC Kumbharapada PS about the discharging the patient Kalia Naik from the hospital 7/1/2008. This is that the report given by me. In this case, the only doctor can give a certificate on the he is fit for giving dying declaration or not. So in this case, only the IO is to the deputy the Tahsildar for dying declaration in this case. IO is PW 31. My lord. On 7/2007, I was attached to the Kumbharapada PS SI police that their day written report Kumbharapada Krishna Chandra Naik Sri P.K. Patnaik IIC Kumbharapada PS registered a PS case number so and so. During the investigation, I intimate rush to the district headquarters hospital Puri As the condition of the deceased Mamata Naik was very serious, I contacted the medical officer, Dr. Abhira Mahapatra, who was giving treatment to the deceased. As the deceased was able to speak, I contact to the IIC Kumbharabada PS to put one executive magistrate to record the dying declaration. I examined the deceased there. The police is examining the deceased, my lord. Is fit for dying declaration or not? It is the ascertain from her that her husband Kalia alias Kartik Naik poured down kerosene on her and set fire. And during the course of setting fire, he also sustained injury in his person. Immediately, I searched her husband, the accused, in the hospital and found him in the undergoing treatment in male surgery ward in the same hospital. As there is a chance of absconding, I request IAC to depute a guard in as investigation was in progress. In that meantime, I got information from the IAC that he himself was proceeding to the office of the subdivisional magistrate for a deputation of the magistrate to the hospital recording the dying declaration of the deceased moment. The IAC issue requisition to the subdivisional magistrate Puri for deputation of a magistrate. IAC issue the requisition for recording of the dying declaration. I sent a requisition to the scientific officer DSLF Puri through the police Havildar BN Misra and deputation of a scientific team.
We continue tomorrow, madam. The same, this will be rolled over. Remaining matters. All right.